who is not here.
Suppose we.
Search.
Oh, what did I just?
Chief Justice, I do believe all parties are online.
Yeah. Is made.
I confirm, Chief Justice, that all counsel is present. Thank you very much.
Thank you so much. Mr. Mango, would you please call the matter?
Good morning. I am the registered clerk for this hearing. Justices of the Constitutional Court, I confirm Constitutional Court, all counsel are online.
Okay. You may call the matter.
I call the matter of Golden Core Trade and Invest Proprietary Limited and Merafong City Local Municipality and another for hearing. Counsel are now invited to place themselves on record. Please note that this hearing is being recorded.
May it please the court, Justices, Chief Justice, I appear for the applicant Golden Core Trade and Invest together with my learned friends, Mr. Curry and Mr. Sila.
Thank you, Mr. Graves.
May it please you, Chief Justice and Justices, I appear for the first respondent with Mr. Diswart.
Thank you, Mr. Mutepe.
Chief Justice and Justices, Mr. Himshe and myself, Erasmus, we appear for the second respondent, the Minister.
Thank you very much, Mr. Erasmus. And before we start, may I just remind everyone to ensure that only one device is in operation. If you have both your laptop and your iPad and your cell phone on at the same time, that tends to interrupt connectivity for all of us. Mr. Graves, are you ready to commence your...
I am, Chief Justice.
Go ahead, please.
Thank you. Thank you, Chief Justice. If I might start with just some terminology. As the court will have noted throughout the matter, the references have been, the applicant has been referred to as Anglo Gold. There was a change of ownership of the company, which resulted in Golden Core coming in, but we will refer to the applicant, continue to do so as Anglo Gold. We refer to Merafong and the Minister. Chief Justice, then a matter of housekeeping. There are two matters for which we seek the condemnation of the court. The first is that the application for leave to appeal was filed late in court due to some confusion about the minister's address. It was done by email by arrangements, but that subsequently was rectified and the documents were filed. There is an application for condemnation. I'm not making any assumptions, Chief Justice, but I will simply leave it at that. If there are further questions, I'm sure they'll be raised. That is the first matter. The second matter, Chief Justice, is a supplementary practice note which we delivered on the 22nd of October 2022, and we asked the leave of the court for that to be admitted and to be utilized. With that, sorry, Chief Justice.
As I understand it, both applications are not opposed. Do you confirm, Mr. Mutepe and Mr. Erasmus?
Indeed, Chief Justice, we do not oppose those.
Thank you.
Thank you, please. We do not oppose either. Thank you, Chief Justice.
Thank you. Condonation is accordingly granted in both applications.
Thank you, Chief Justice.
Okay,
Justice,
you may keep on, Mr.
Then to move on, the opening point is this. Anglo Gold supports the SCA judgment, the latest one, on the principal issues before that court, except for the limitation of that relief which was granted. And those principal issues, Chief Justice, is the question of the enforceability of the minister's decision. That's the first point. The second point is Merafong's delay in launching its review. And the third point relates to the finding of the SCA. that the constitutional challenge has not properly been raised. What we'd seek to do, Chief Justice, is then to turn to the original application, which was launched by AngloGold against Merafong, Minister cited as far back as 2011. And we just wish to deal briefly with the background to that. As the court is aware, on the 18th of July 2005, the Minister of Water Affairs, use the term loosely, I think the name may have changed, but made a decision in terms of Section 8 of the Water Services Act, which effectively, and we emphasize effectively because that was the SCA's finding, overturned the surcharges which had been imposed by Merafong on the supply of water for both domestic use and industrial use. And if I might just flag, as we will return to it, that is found, that decision is found in the core bundle, CB 19-20, and we will return to that in due course. As is apparent, the municipality Merafong, notwithstanding that decision, continued to impose the surcharges, and importantly to emphasize is that those have been continually imposed annually since the minister's decision. There is a table of water tariffs, etc. And I'll just once again briefly refer the justices to that. It's found in volume 4 of the bundle. This is an annexure to AngloGold's answering affidavit in the review application. It's a spreadsheet, once again, and if it is numbered, was an annexure CLS 10, and on the left-hand side, there are a number of columns. The important features there is that there is a rate given for Merafong. It's a flat rate, and it's common cause that from 2007, that was a flat rate. This table
Sorry,
runs...
which page is this, Mr. Graves?
Sorry, I didn't give the page. My apologies, Chief Justice. It's 338-339. Apologies.
Thank you.
It is in volume 4. And the flat rate has been charged. This table runs from, it's not for the full period, it runs from January 2009 through to August 2017. Once again, I just identify that. We will return to that in to emphasize certain features of that, Chief Justice. The payments that have been exacted under pressure, under protest. They've been by AngloGold. That was pointed out in the first judgment of this court, the majority, what we call Merafong 1, and that has been done under threat of protest. We see our colleagues query that in some way, but we'll just give once again the reference for that. There's a letter CB 79, that's core bundle 79. That is a letter from the municipality, which in fact referred to an outstanding arrears. And the point that was made rather threateningly, that's at 79, was that it's a courtesy letter. This is the Merafong writing in September 2007. We will be implementing the appropriate steps in terms of the provisions of clause 10 of the agreement to limit water supply to your mine. And the following page on CB 80, a letter from AngloGold's attorneys, who challenged that but said that the payments would be made under protest. Quite clearly was a payment under protest, and that features in the relief later. So on the back of that, AngloGold applied to enforce the minister's decision, and as I've indicated, it instituted its application during 2011. Might we refer the justices to the amended notice of motion, which is found in volume 4 at page 329. And it runs through to 332. The paragraphs numbered 1 through to 6 have always been, those are the original paragraphs, and the court will see what is asked for. The first prayer is to a declaration that Merafong may not levy a surcharge on water for industrial and domestic use. Then continues, there's certain application for directives. In paragraph 3, there's reference to an interdict. Paragraph 4 references the directive given by the minister to the effect that there should be negotiations on water for domestic use. And once there's an application, paragraph 5, that Merafong be directed to negotiate. If we can turn then to, on page 330 at the foot, paragraph 7, the first part of that, the alternative, is a review in terms of PARJA. What was added later was a reference to the principle of legality about the decisions made by Merafong in its resolutions, which were then promulgated. And importantly, at the top of 331, what he said is, and all such resolutions subsequent to that extent that they impose tariffs or surcharges. The SCA found that, in its judgment, we'll come to that AngloGold had abandoned any attempt to set aside the conditions, tariffs after the 2004-2005 year with deference. That is incorrect. The amended notice of motion, just to indicate to the court, was an attachment to the replying affidavit in AngloGold's original application before the High Court, which was heard by Justice Kabushi. And that has been granted. The amendment was granted. To return to that relief, the relief that is sought, the principal relief has remained the same, and it is this, Chief Justice. It is to enforce the minister's decision. The SCA referred to that as a declaratory order. It was partly declaratory and partly directory. But that relief has remained constant. It has never changed. That notice of motion is in fact sets out the relief that has in fact been sought. Now, what is found by the Supreme Court of Appeal, you'll find the judgment of that court is in volume 9. And if we could refer to page 907, where the finding, finding is made regarding the conduct of the municipality. 907 at line, I think it is 14, in the middle of that line, insofar as the municipality exacted tariffs for water for industrial use from that date, talks about the minister's decision in excess of the charges by Rand Water. The minister's decision rendered such excesses unlawful. AngloGold was entitled to a declarator. In the following paragraph, the court also deals with the question of domestic water for domestic use, and with respect correctly finds that also was effectively set aside. Now, the limitation that we challenge in this appeal is that found in the order. Once again, it's a judgment of the Supreme Court of Appeal, page 910, paragraph 80. And we refer specifically to paragraphs 2.2.1, that is the tariff for the industrial use for that limited period, declared to be unlawful, and in 2.2 that relates to domestic use. As the court will have noted, our position before appeal is that limitation was not warranted. And what is sought now is relief that would remove that restriction. So that's the first part of relief, which has always been part of AngloGold's relief. The second part of the relief which is sought is a repayment order, and the court will have noticed that is in accordance with the draft order which has been submitted, which I'll get to in due course. It was attached to AngloGold's practice note. And we ask that It was sought in the Supreme Court of Appeal, but was not granted. So that, as far as background, we then turn to what we contend is the primary principle and the primary matter, which is the issue of legality. And we say the following in this regard, that the principle of legality at its most fundamental level is an incident of the rule of law. This is one of the founding values of our constitutional order. We reference there the third edition of administrative law by Professor Hoekster and her colleague Penfold, and that is found at page 356. There are a number of statements to that effect. What we further reference is 3 statements from Merafong number 1, and we continue to refer to it. That is the first decision of this court. The first principle is this, it's found at paragraph 43. What the majority said is the following: what it, being a reference to Kurland, requires is that the allegedly unlawful action be challenged by the right actor in the right proceedings. And importantly, until that happens, for rule of law reasons, the decision stands. The second point that we make, principle which is articulated, found at paragraph 60, and it says that as a good constitutional citizen, Merafong should either have accepted the minister's ruling as valid or gone to court to challenge it head on. Third principle is at paragraph 61, where the court said it's a fundamental principle that the state should be exemplary in its compliance with the fundamental constitutional principle that proscribes self-help. Now, AngloGold's case before this court, and has always been, is that the Merafong has failed to conduct itself in that manner. Its failure is in fact ongoing. Turning to the next theme that we raise, and this concerns the regulatory environment underlying the minister's decision, which is of course the Water Services Act. And what we emphasize at the outset is that what happened in these circumstances back in 2004 and 2005 was a transitional process whereby the old 1956, I think it was, Water Act, which made water, referred to private water and placed it under state control, that was transitioned to municipalities. And we find that in the fourth part of the preamble to the Water Services Act, where there's an acknowledgement that municipalities have the authority to administer water supply services. Chief Justice, if I might just mention, there is a rather complex set of definitions in section 1 about water services, water supply services. What we are talking about presently is, in all cases, we're at one with our colleagues for Merafong, it concerns potable water. But the distinguishing feature that the Water Services Act draws is that it's the use to which water is put, which determines how it's dealt with. We don't believe we get into the debate, the constitutional debate in our submission doesn't arise as to whether there's authority. We adopt the position that the Water Services Act regulates water for both domestic and industrial use. And we as AngloGold receive that. A brief reference, Chief Justice, I don't wish to burden the court, but just to refer to some sections of the Water Services Act which support this important changeover, the transition. The first is section 4, sub 1 of the Act. Water services must be provided in terms of conditions. We emphasize conditions set by the water services provider. That's an important point because it's about this, what is before this court concerns not just tariffs, it concerns the conditions of use. So that happens at that primary stage. What for sub 2 C and Roman 2 provides is for the conditions must include the determination structure of tariffs. So there's the link between conditions and tariffs. And in sub 4 of section 4, a person who uses water services does so subject to applicable conditions. So if we pause there, what happens at this transitional point is that the supply which is to be provided is provided on conditions. We then move to sections 6 and 7. I'll use just 6 as the primary point. And what we find there is once again the reference to conditions. We find particularly in section 6, 2A, there must be an application for approval. And that then is granted in terms of B, Roman 1. It's granted after which the conditions of approval apply. I'm not going to continue. 7 follows essentially the same, the same structure, Chief Justice. Then there are further regulatory provisions which are ongoing, and that we find, and I'll give the brief references. The court will refer to Section 9 of the Act. So Section 9.1 says that the Minister, this is again the Minister of Water Services, Water Affairs, I can't remember what the latest is, may from time to time prescribe compulsory and national standards. If we drop down to sub 3 of that, it says in prescribing the standards, the Minister must consider a certain number of matters. And in sub D, we find a reference to the norms and standards for applicable tariffs. And what we find importantly at sub 4 of section 4 is that every water services institution, that includes Merafong, must comply with the standards. So that's peremptory. In paragraph 10, we've got further provisions. I'm not going to go to those immediately. They also relate to various regulatory parts, and just to refer the court finally to section 62 of this act, which has the heading monitoring of water services institutions, that includes municipalities. And sub 1 says the minister in any relevant province must monitor the performance of every water services institution. I'm going to leave those provisions for the moment. If I can then ask the court to turn to the minister's decision, which we find at CB 19. And what we find in paragraph 2.1 is a reference to the conditions imposed. So there again, this is part of the transition. And those conditions, which were then considered by the minister, who found that the surcharge applicable to industrial water should not be levied, and there was reference to the unreasonability of it, and there was then a directive given regarding the water for domestic use. Now, we find also that reference to unreasonableness is what, in fact, drove the minister to her decision. And she makes that decision. It is based squarely within the Water Services Act, and particularly those paragraphs that we referred to. We referred earlier to the finding of the Supreme Court of Appeal that the necessary implication was that the water for domestic use was also set aside. That was found in volume 9 at page 907, paragraph 73. And the Supreme Court of Appeal found that the declarator Merafong could suit that. That is, it loops back to, Chief Justice, it is the principle of legality. The minister gave a decision. This court, 2016-17, said that Merafong should either challenge or accept. It did neither. And we are back here after 14 years of litigation. The finding was about the review was out of time. We'll deal with that after in response. The remedy, if we can turn to, the remedy which is sought is enforcement primarily, and as indicated, also seeks a payment remedy, which we find authority in two decisions I'll refer the court to. Section 172 is sufficiently flexible to permit wide range. That's in the EFF versus Speaker of National Assembly in our heads at page 35. And we point out that Merafong knew from the very latest in April 2006 that it had a case to make in court to overturn the decision. That is in a letter from Merafong, and that is at core bundle 57 to 58. We pause on something we found in our Merafong's heads before this court. They characterize Anglo Gold's conduct as intransigent and male fide during negotiations. And we wonder what label Merafong would attach to its own unlawful conduct over a period of close to 20 years in refusing to take the right steps. That criticism of Anglo Gold is unjust. The reference is made in the heads also to an action brought by Blyford Eitzig and Doornfontein against Merafong in 2011, concerned the same matters. And though there was a concession which meant that no order needs to be made, Justice Patudi made the point in his judgment that the minister's decision was valid and binding. That's found at CB 129. Now the question is, why did Merafong not recognize regarding Anglo Gold that that was the position? What we find in the table, and I don't wish to, I'm running short on time, the table shows, and I'm sure I'll get to that in questions from the justices, from 2009 to 2017, which is not the total period, 126 million rand has been overcharged by Merafong. And we refer finally, to Chief Justice, to the SCA judgment in Thabo Shweu, Rural Forum versus Thabo Shweu Local Municipality. That's in paragraph 53.1, page 31 of our heads. It refers to the knock-on effect. So one, there it was rates. Rates are determined. What follows thereafter is built on the preceding period. That's logical. So the successive impositions are in fact equally unlawful. We also, Chief Justice, referred to the judgment, recent judgment of this court in Casino Association versus MEC for Economic Development, found in our heads, paragraph 53.2, which recognized a right of recovery by the condictio in debiti, where payment is made and the court uses these terms, deliberately made, but nevertheless involuntary and under pressure and protest. That's exactly what was made. So, Chief Justice, if I can turn briefly to the order that is now sought, the draft order. We ask for, in paragraphs 1, 2, and 3, this part deals with the past litigation, but importantly in paragraph 5, we ask for the declaration in 5.1 that the surcharge on industrial water from 1 July 2004 in excess of the tariff be declared unlawful. That is essentially the form of the SCA judgment, but it extends the period. And we ask for the same in 5.2 concerning domestic use. In 5.3, we ask for a relief which we've only sought now, and in accordance with the recent jurisprudence of this court, is that the Merafong be directed to pay the difference between the Rand water tariffs from time to time and the amount that has been levied on Anglo Gold for both industrial and for domestic use from 1 July 2004. We ask for interest, and we ask also for the costs of the various proceedings before, as we asked for in the Supreme Court of Appeal. If you just bear with me, Chief Justice. Yes, the cross appeal, our attitude to that, very briefly, is that the 3 Merafong principles that we've articulated apply equally. And in fact, it is simply the flip side of the coin. Merafong was required to challenge or comply, did neither. And that the the constitutional application was never properly before the court as found by the SCA, and similarly the delay in launching the appeal was egregious. It should not. Thank you, Chief Justice. Those are our filing submissions.
With 3 minutes to spare. Well done.
Yes. Thank you, Chief Justice. I had some assistance from my colleagues.
Do you have questions for Mr. Graves, colleagues?
Yes, Chief Justice, through you.
Justice Chick.
Mr. Graves,
Justice Tsiki.
on the limitation, the SCA in paragraph 56, in paragraph 56, it is in page 899, volume 4. It limited the relief only to that 2004 to 2005 financial year, because it said that new tariffs were introduced for the other year, that is the subsequent years. And I'd like you to actually, you know, develop this, because until I read this paragraph, I had thought that perhaps the minister's decision, having read the letter, applied to the imposition of the tariffs. But when I read this, the reasoning by the SCA, it bothered me, because it is true that for each financial year there would be tariffs that are imposed, and the SCA understood then to mean that the minister's decision was only applicable for that financial year.
Yes, thank you, Justice Chiki. That is a primary feature of our appeal. Our position before this court is that the tariffs, and we don't seek to avoid the debate about tariffs, the tariffs are no more than conditions. But what is most important in that proposition which we put is that the conditions at the time, the transitional time, that were announced by Merafong, and that's what I can do, Justice Tiki, with your permission, is to refer to the progression, because this will help if I might suggest that. If I could ask the court to turn firstly to volume 6 of the record at page 628.
Yes, I found it.
Thank you, Justice Tiki. We'll see the letter is one from Merafong. It's dated the 11th of February 2004. It's written to Driefontein, but the same letter was written to Anglo Gold. And just if I can give a reference to the justices, it is in volume 5 at page 514. I'll just get my colleagues to check that that is right. And the heading is notice to apply for approval to be provided with water for industrial use. It's common cause before this court that the application was made for both, and that was accepted in the Merafong 1. And paragraph 1 says, with effect from 1 July 2003, Merafong City Local Municipality has been accorded the powers and functions of a water services authority. That's important. That is the first time which Merafong now takes over its duties and functions as a water services authority. Goes on in the next paragraph. As the Water Services Authority, we hereby request that your institution must apply for approval by the Merafong City Municipality for the supply of water for industrial use, and there's reference to section 7. If we turn then to the core bundle, and that is at CB7,
Yes.
Yes, what we find is the letter in response from Anglo Gold, which is dated 8 April 2004. That's pursuant to the invitation. And this is a letter addressed by Anglo Gold. It talks about water supply. It references in the first paragraph 11 February. And in the final paragraph, unnumbered, Anglo Gold requests the approval of Merafong in terms of Section 7 to continue obtaining water from Rand Water for its mining operations and associated domestic applications. Sadly, that was incorrect, was inaccurate, because in fact the section which deals with water for domestic use is 6 and 7 is for industrial use, but nothing turns on that. And that is the commencement, Justice Tsiki, of this process of taking over. And our point, and to come back to your question, the point is that the conditions that are imposed, which are those referred to in Section 4 of the Water Services Act, and it's not only tariffs. What Section 4(2)(c) provides for various things: technical conditions, tariffs, conditions of payment, procedures for limiting, etc. There are a number of things. Tariffs is but one of them. And those conditions, so it was the first time, it was the first opportunity for Merafong, with its newly conferred authorities and powers in terms of the Water Services Act, to in fact manage the supply of water within its jurisdiction. It imposed tariffs. There was an appeal against those tariffs, and the minister ruled that the tariffs were unreasonable. She set aside industrial, and she made an arrangement on domestic, and we adopt the reasoning of the Supreme Court of Appeal. So our position, Justice Tsiki, is this: those original conditions which were sought to be imposed by Merafong were wrongly sought to be imposed. They were set aside. We are still, 20 years later, we're still at that primary point where the conditions of the transfer, this transitional transfer, have not properly been determined. And the fact that Merafong continued to pass resolutions and to approve tariffs on every fiscal year does not change that position. The minister's decision is binding, and the decision said your conditions of use, and that's what we find in the 2.1 of the ministers, your conditions of use, I find them to be unreasonable. Now that decision stands before this court, and as long as it stands, that in fact brings us back, after all this time, it brings us back to that point. Merafong must go back and must redo that process. It's never done so.
But perhaps what caused the confusion is the second sentence in 2.1. Perhaps that's what led to the SCA's understanding, because that second sentence then refers specifically to the tariff increase, and then it goes on and on about the tariff increase itself.
Indeed. With respect.
So what you are submitting is that the minister was not happy with all the conditions, and then she decided to address the issue of the tariff.
It's the one which, sorry, I interrupted. Sorry, Justice Tsiki.
Yes, I'm done.
Sorry, I do apologize. Perhaps, yes, with respect, and if we turn, and perhaps it may be of assistance, if we turn to Anglo Gold's appeal, back then to the core bundle, page 10. And what we find from page 10 through to page 13 is Anglo Gold's appeal. And of course, what is raised there are matters which concern the manner in which the tariffs have been determined. And if we can ask the court to look at page CB11, at the last paragraph before that table, the point is made that the tariffs announced are considerably higher than that of Rand Water, and that table sets them out. On the following page, there's a reference to the increase on water for production use, that is industrial use and domestic water. And importantly, Justice Tiki, in the middle of that page, what AngloGold says is the fact that the tariff announced by Merafong is excessively higher than the equivalent Rand water tariff, while the municipality is not adding value. That's an important finding with respect. And we'd ask the court to have regard to volume 8 of the bundle before the court, which in fact is Merafong's letter, which the minister had asked both parties to refer. If we can ask the court to turn to page 746.
Yes, thank you.
Yes, this is the letter of 7 September 2004. It's Merafong's response to the appeal. And if we can ask the court to refer to page 747 at the foot of the page, Roman numeral 4. And just to pause before dealing with that, this is Merafong responding and giving the minister information on one of the important matters which is required to be dealt with, because the costs of providing the supply are one of the features that are taken into account when it comes to determining tariffs. And if you'll just bear with me, I just want to ground that in the Act and in the norms and standards. Just bear with me. It is in the norms and standards. Perhaps I can just briefly give the reference. This is in the Government Gazette. And what paragraph 2 of that regulation says is that a water services institution must, when determining its revenue requirements on which tariffs for water service are based, take into account at least the need to recover the cost of water, that is A, and in B, it recover overhead operational and maintenance costs and costs of capital. Sorry for jumping around, just picky. But that is what the regulatory environment requires. And with that in mind, if we look at 747, page 747 of volume 8, what we find there is Merafong telling the minister about its process. It says, in nominating Rand Water to be a water services provider, we were alive to the requirement of section 8.3. And if we go back to 8.3, what 8.3 provides is that in determining what is reasonable, the water authority must consider the following factors to the extent thought to be relevant, and one is the cost of providing. So what they say is we considered implications. This is continuing at page 747, supplying water from our own infrastructure. We found that unnecessary, as Rand Water was supplying, and the mines were generally happy. And importantly, in paragraph 2, the practicality of providing the water services ourselves was ruled out, would unnecessarily increase the operational cost of supplying water by creating additional infrastructure. So if we pause there, the municipality is saying to the minister, we don't carry that cost. And we thought it was unnecessary, and it's on the papers, and we'll find the reference. I'll ask my colleagues to find that, is that the infrastructure to provide this is provided by the mines themselves. Rand Water pipes the water to the mines take it further. The municipality incurs no cost. And then turning the page to 748, continuing, other factors of quality and reliability, etc., indicated that our approach of nominating Rand water service provider to the most economic and technically sound decision. And in the following paragraph 4, it again refers to the socioeconomic and conservation benefits with the municipality self-taking over. So that is, in our respectful submission, to come back to your question, Justice Tsiki, and that may be where the confusion with the SCA came in. But the minister was looking at those factors, and the municipality says that it did not incur those costs. And that's why the minister comes back and says that the increase that is provided for is unreasonable. She's having regard to the regulatory environment We read that quite clearly as one of the features. And of course, it comes back to the point. If the original tariff setting was not done in accordance with the environment which is set out in the Water Services Act, that is what the minister has found. Well, it's never been corrected. And passing tariff increases every year doesn't cure the irregularity and the unlawfulness. And if that answers the question, Justice Tsiki.
Okay, thanks. Can I then move? Yes, it does. Thank you. Can I move to another point concerning the delay? The municipality says that there was a stage where they were under the impression that, in fact, the matter has been settled. And it's one of the reasons they give for the delay, to say that they thought that Anglo Gold had, in fact, reached a form of agreement with the municipality concerning this. And the impression it gives me is that they are saying then that during that period of negotiations and during the period they thought that you had an agreement with them, they were justified in not doing anything.
Yes. We've seen that, Justice Tsiki, and we're puzzled about it. If we take the chronological process and we look at this, so the applications are made in 2004 by the mines, and the Gold makes application. The minister rules then on appeal in July of 2005. Now, there was a process of negotiation, that's absolutely correct, but that ended quite early. When eventually one of the senior members from the municipality said that we can't continue with these discussions because we can't meet our revenue requirements. And I can just find the way that it was dealt with by the Supreme Court of Appeal when dealing with this point of delay, and at which is the latest point when the municipality knew that it knew that it had a case to make out before the court to overturn the appeal. And perhaps the easiest way to do this is to go to the core bundle, CB 57. Yes, Justice Tsiki, this is the letter from Merafong to the minister in April of 2006. And if we turn to CB 58, paragraph 7 is of importance. This is Merafong speaking. It has become imperative for us to resolve this matter decisively. As a result, we have obtained an opinion to the effect we have a case to make in court to overturn your decision. Now, that tells us a number of things. First of all, it tells us that whatever previous misgivings there was a clear understanding by Merafong that it was required to act as the Constitutional Court, Merafong 1 said it should have acted. And when you have a case to make out, there can be no question that this is something which has now been settled, because what Merafong would then have said to the minister is that we've reached an accommodation with the mining company, and this is not an issue anymore. So what is clear from this is that there is an ongoing dispute, and there was certainly a challenge raised by Anglo Gold at an early stage. If I could also refer to paragraph 37 of the judgment of the SCA, which is in volume 9 and at page 892. The foot of the page, Justice Tsiki.
Yes.
And it continues, it starts on paragraph 35, where there's reference to the attorney, Mr. Nalani, and we find at the lines 16 and SCA records absent agreement on this. This is about the state of the tariffs. The minister and the municipality, as organs of state, are obliged to seek consensus before resorting to legal action. That is now, and that process is ongoing. And then we go to paragraph 37, paragraph 36, Mr. Nalani realizes that if there's no agreement, legal action would be required. And then 37, in fact, refers to the letter that I have referred to, which is there quoted as the 5 April. We turn to the following page, 893, in paragraph 39. The SCA found that the municipality labored under no apprehension that it would simply ignore the decision that it had obtained. The minister's decision had to be overturned. So whatever the position may have been in that period, that negotiation period, just Tsiki, between 2005 and 2006, by this stage, the municipality on its own version knew that it had to take steps to overturn this decision. There was no settlement, and any suggestion that it believed there was a settlement is simply contradicted by this letter.
Thanks, Mr. Graves. Thank you, Chief Justice.
Thank you.
Mr. Graves?
May I follow
Mr.
up
Graves?
on that, please? Sorry,
Yes.
please go ahead, Justice Mtantla.
Thank you. Mr. Graves, still on this tariffs and conditions issue.
Yes.
If I understand you well, the conditions, the decision of the minister, set aside the conditions of the surcharge which was imposed by the municipality. And
Yes,
as long as that decision is not set aside, that decision stands.
Yes.
And you say that if the tariffs that are imposed after 2006, whatever figure that is being imposed, they should have, it's also, you are not bound to pay those monies. And whatever that you paid under protest. Now,
Yes.
I want to know from you, because there's a claim for a repayment. When you make that claim, have you taken into account the fact that there is still some monies that should be paid by Glencore, Golden Co?
Yes, sorry, I perhaps didn't clarify that, Justice Mtantla. The money that we seek for recovery is in fact in respect of the surcharges. And perhaps I can just round that in the papers of Anglo Gold in the review application. If you'll bear with me. And we find that it is in Justice Mtantla. We find it in volume 3 of the record at page 267. And I've asked the court at the same time to turn up in volume 4 that spreadsheet which I previously referenced, which commences at 338.
What is the page for the spreadsheet?
Spreadsheet, Justice Mtantla, is volume 4, page 338. So if I can turn first, if the court has the reference in the, this is the answering affidavit of Anglo Gold, 267, and paragraph 15.5.8, referring to the spreadsheet, for the period January 09 to August 2017, Anglo Gold has paid an additional combined surcharge on domestic and industrial water. Now, that is what is sought to be recovered, not the Rand water cost. Because I think what Justice Mtantla, you're aiming at is that there is a cost for water that is charged by Merafong. Part of that cost is the Rand mine or Rand water cost, as there's a surcharge. And then perhaps if we can turn to the spreadsheet that is in volume 4, page 338. If we start conveniently at the top of the page, you'll see there's the first column is the invoices. It gives every month's invoices. We have the Merafong rate. What I've indicated earlier in my opening was that that amount which is found there, so the R5.03, that was a flat rate. And despite the indication and the requirement in the norms and standards, which is in paragraph 4 of that regulation, there must be a differentiation between industrial. The municipality said we're imposing a flat rate. So that's the first point. If we look at domestic bulk and industrial, which is the 2 columns under Rand Water. So just to clarify that, Justice Matlantla, what Rand Water has always done throughout this period is to levy a charge to the municipality for, it's the same water, but there's a differential charge for domestic use, which you'll see in that first month is 3.2 cents per kiloliter. And if we see industrial, that is higher, it's 4.8, I think it is cents per kiloliter. And that continues throughout. And if you track down under the Merafong rate, and you get to the bottom of the first page at 338, it will be noted that the Merafong rate is charged flat rate 11 Rand and 59 cents. For domestic water, the charge is in fact 5.9 cents. So it's almost 100% more. And for industrial, it's 8.9 cents. So on industrial, it's about 75%, and that differential is continued. We haven't continued the schedule, but on this table, that is the amount that was payable when this affidavit was done, and that goes up only to August 2017, and it represents only the surcharges.
Thank you.
That answers the question, Justice Matlantla.
May I just, on that, please, Mr. Graves, follow up? So this argument you say, I just want to see if I understand, Mr. Graves, this argument of the municipality that, and which the SCA seems to have adopted, is that it's not dependent on a financial year budget from year to year, that the illegality or the unlawfulness is ongoing. That's what you are saying?
That's what we're saying with respect, Justice Majid, yes. Because the minister's decision stands.
Yes, yes. So when I ask this question, I immediately must confess that it wasn't raised by the municipality, and I find it quite curious. But it is a concern of mine. This is a substantial amount that you are claiming, and just for the moment, assuming that we are with you on this repayment claim, everything else and the repayment claim, are there not grave financial implications for this municipality, or should we simply take the position that they hadn't raised it? If it was a concern, they should have raised it. They didn't, so we shouldn't be concerned about it.
Yes. Justice Majid, we would never suggest that a court shouldn't be concerned about something which has implications. The difficulty in managing that, and it's why we say that the court will look to uphold the principle of legality, is that the municipality has flouted this. And if I can just pause on that, if the municipality, acting sensibly, had taken a view that says, we don't agree with this decision, we're going to review it, and we're going to now have this resolved, and we will move on. It didn't do so. Now, the consequences of that are unfortunately solely due to the municipality's conduct, which has been criticized by the SCA and by other courts. But on the practicalities of it, I can't say to the court that my client Anglo Gold, appreciating the difficulties, will waive this amount. What I can say is that it serves no one's purpose, certainly not the mining companies, to cause a municipality effectively to be knocked over. So some manner needs to be found in managing the outcome of Merafong's own unlawful conduct. And as with respect, you've pointed out, Merafong it does say it's got lots of challenges, whatever all municipalities do, but Merafong has not made out that case properly. And we would say that the court would enforce that right to entitlement to payment, because that is the consequence. That's what the principle of legality requires. You can't get away with your own unlawful conduct. But when it comes to the enforcement, we would certainly acknowledge that this would have to be managed. And of course, there are a number of mechanisms. I'm not authorized to speak about them, but it could be to provide some kind of, there would be a discount at a certain point over a period of time, which may in fact have to be a lengthy period of time. But that could only be done in a process between the parties. And from my client's position, recognizing the consequences and not ignoring those.
Thank you.
Thank you.
Yes. Now, just a final question from my part also deals to an extent with the question that Justice Tiki asked you about the delay. In your papers, you call, as either in your papers or in the submissions, you call the delay prodigious on the part of Merafong. Now, one must take into account that there has been ongoing litigation for a long time. And one must take into account this period of negotiations which Justice Tiki alluded to. But as I understand your case, the clock started running as far as delay is concerned in the review for Merafong at the latest in April 2006, when they, from their own mouth, said that we appreciate that we must go to court. We have to take a case to court. You say that's when the clock started running.
So yes, with respect, yes. So to the extent that there can be a contention by Merafong that says there was this process, and perhaps what I can do, Justice Majid, is refer to the a progression, an exchange with the municipality, if you'll bear with me, which in fact showed when the municipality decided it wasn't going to engage anymore. Sorry, if you'll bear with me. It was in an engagement. There were ongoing engagements, and it is.
Mr. Graves, if it's going to take too much time, you can always come back to it later and have your juniors have a look for it. I remember reading that one of their senior officials, it wasn't the MM, it wasn't the municipal manager, I think, but one of the senior officials reverted and said, look, we can't keep on negotiating and we are drawing the line here. I remember reading that. So you could refer us to the passage later. But can I get the point that you are making? You say the municipality drew a line and said we stopping negotiations here. Could you take it further from there? I know I've read it. I've seen it.
Thank you. It's Mr. Radibala. I think we'll
Mr. Radibala,
thank you.
Correct.
I'll get the juniors. So the point is this, and it's set out in some detail by the SCA, which the court will have seen. At the point by April, whatever the position was, so negotiations were finished. Not only that, but any possibility of this dispute being managed through the legislation, and it's an acronym which I've forgotten for the moment, with the minister had in fact come to an end. And that may well have been because the minister was intransigent. We don't level a criticism because it wasn't resolved with the minister. What we do say is that as a matter of fact, there was no more opportunity. So the negotiations have failed. We'll find that reference for you, Justice Majid. And the minister had either been unwilling or simply it didn't happen. So at that stage, you have to do something.
So April 2006, and just remind me, when was this review launched by Merafong?
Yes, it was launched in, my recollection is February 2011, Justice Majid.
Yeah.
I just want to see if my colleagues have managed to locate that. What volume is it? In the front. Sorry, I think I might have it.
As I said, Mr. Graves.
Yes, we'll come back. Perhaps we can do that. I'm sorry.
Come back to that. I don't want to delay. I don't want to delay proceedings. So we're looking at almost 5 years on that. It's April 2006 to February 2011 on that chronology. What is the municipality's explanation, A, and B, why do you say it's unreasonable? On the face of it, 5 years does seem unreasonable, but what is the explanation?
Yes. Well, the explanation that is given maintains, Justice Majid, that the minister's decision was wrong. It has always taken that stance. It hasn't changed from that stance, and it simply, I think that what happened is that we only found, if I might just interpose, these engagements with the minister, which obviously AngloGold was not aware of, only became apparent once the papers were filed, and I think came from the minister who filed the record. So we didn't know about this, but the process simply did not move ahead. And Merafong's stance has remained throughout. It remains today, the stance. The minister's decision was wrong. But what it can't answer is why it didn't take steps when in April 2006, it knew we have a case to make to set it aside. That means one thing, it means review. Sorry. Yes, and what they do, and as was pointed out in the Merafong 1, is that Merafong was able to do so, and as found in Merafong 1, they had their hand on the tap. So there was no incentive from their perspective, wrongly so, but there was no incentive. They knew that they could control it, and perhaps what I should do, just once again refer to the letter where it was indicated that Merafong.
No, I've had a look at that. That's a letter where the threat was issued, and you've referred us to it before.
Yes, we have indeed.
I've seen it. I've made a note of it. I said it was the last question, but this is the last question. Actually, you say we don't get to the constitutional challenge at all. Can I understand very briefly? Is it because you say because they don't get past these preliminary issues that you've dealt with now thus far in questions?
Yes, Justice Majid, we say it's because the challenge was not properly raised, and in that regard, it was put as clearly as possible in the judgment of this court.
Well, I've read that too. Can I just speed it along and say what this court said was that it was almost a last minute spur of the moment. In fact, what they done is they included it a day preceding the hearing. Is that what you're referring to?
That's what the SCA, the Constitutional Court in the first round said, from the bar was said that the point is alive on the papers, but it had not been pursued in the previous, and I think Justice Majid, you and Chief Justice sat in that decision in the Supreme Court of Appeal. But what was found in this, it was found by Justice Strydom and upheld by the Supreme Court of Appeal, is that it's the day before they deliver a notice of motion for the first time, where they seek an order to declare Section 8(9) unconstitutional. And as pointed out by the Merafong 1, is that the first challenge, which was a conditional challenge, was not a full-blooded challenge. If I can just refer the court to that provision. It's found in the judgment of Merafong 1, paragraph 66, where Justice Cameron, this is the majority, refers to the conditional counter application. And what the Justice points out, he says, the order did not seek the setting aside of the minister's ruling, only a declaration that she had no statutory or constitutional power to take it. It wasn't a direct frontal challenge. Simply said, well, on interpretation, she doesn't have the power. That is the point we make. And that's why we say, and it was a belated attempt. Why, we don't know, Justice Majid. We haven't heard why that is. When the Constitutional Court says we'll give you an opportunity, 1997, to raise that point, it's not raised until the day before the hearing.
Very much. Thank you, Chief Justice.
Thank you. Thank you. Mr. Chief Justice, if I may, Mr. Grace.
Yes, Justice Turan.
I would like to take you to the judgment of the SCA, and I'm going to explore perhaps what my colleagues have already, especially Justice Chitpi and Justice Majid, because I think it lies at the heart of part of the applicant's appeal. and this is the minister's decision. If you look, please, can you look at paragraph 50 of the judgment of the SCA? It's in volume 9.
I have that just
at page 896. Sorry, volume 50, paragraph 56.
56, sorry.
Yes, 56.
Yes, I have that just.
The SCA says, about 8 lines down in that paragraph, new tariffs were introduced for the 2005-2006 financial year. It follows that when the minister set aside the specific tariffs that the municipality had decided on in 2004, her appeal jurisdiction could not and did not extend beyond the life of these tariffs. And if we look at paragraph 60, just over the page, it says, the minister is not a court of law. Her reasons are not precedent. What matters is what decision she took. That was her decision, that is, was restricted to setting aside specific tariffs of application for a limited time. What is your response to that line of reasoning, Mr. Graves?
Thank you. Well, if we could just take that and look at that practically, Justice Tron. So we've made the submission that what the minister was concerned with was conditions, and it happened to relate to tariffs. But if we had to take that to its logical conclusion, what it would mean was that at this transitional phase, Merafong had failed to apply the proper test and process to set aside the tariffs for that particular year, 2004-2005. And that for every subsequent year, there's now a gap, because what the municipality does, as we've seen from the schedule, municipality increases, and that's what an incremental increase is. So in fact, it starts from a base that is higher than it should be. That's the first point. The second point is that the impracticality, I say this with deference, of the finding made by the SCA would be that every year, and it can only be done every year, because you can't do it on this reason, you can't do it in advance. Every year, AngloGold would have had to have instituted another claim, because that's what, and we'd have to then, on this reasoning, the appeal jurisdiction of the minister is limited to that particular year. We would now be in our 20th year of challenge. Now, I'm not suggesting that the court was seeking to impose something that was simply impractical. That's the implication, intended consequence of that. And that's why we say that the minister's ruling on the conditions, in fact, at that very first stage, this is the first opportunity that Merafong has to invoke its powers, and it has a power to impose tariffs, but it does so incorrectly. So whatever follows from that, and we find support in that in the Talbot-Swale judgment, each one, it's a knock-on effect. So we find our submission is that the minister, although she references those tariffs, she actually she starts her ruling by saying the conditions imposed. And if that condition is originally wrong, it's always wrong. It's the same as in casino.
Yes, but what I would like you to address specifically is what the SCA says in its judgment at paragraph 6.
Paragraph
and
60.
It says,
sorry, missed that. I'm sorry.
Paragraph 60, I'm sorry, 60.
Yes, I have that, Justice.
The minister's decision, yes, is restricted, or the impact of her decision is restricted to the tariffs that she was dealing with for that particular year.
Yes.
Is that principle wrong in law, and why?
We say with respect that it is wrong. We say it's wrong because, and I don't wish to repeat myself, is that what the municipality must do, what the Act requires it to do, leaving aside the minister's decision, it's got to impose at that transitional phase, must impose tariffs in accordance with the prescripts. And the Act says you can't have unreasonable tariffs, and the norms and standards back that up. So once that first tariff setting is unreasonable and accepting as a matter of logic that every subsequent tariff setting follows the preceding one, then what follows must in fact be implicated. And that the appeal jurisdiction, which the SCA says was restricted, it's restricted perhaps, and I simply say this notionally, regarding that tariff, but it's not restricted as far as the manner in which the conditions must be imposed. And it must be our contention. It's that if it starts wrong, everything that follows is in fact equally wrong because it's knocked on throughout. So if Merafong had gone back in the next year, let's take it notionally, and had reconsidered these tariffs and had done so in a manner which was acceptable, and we don't even have to involve the minister, it's acceptable to the mining houses, but taken into account that it incurs no cost, we wouldn't be here, but it didn't do that. Simply went through a progression.
If I understand what you're saying, Mr. Graves, you're saying that the legal principle that comes from the minister's decision should be held to apply to the setting of subsequent tariffs.
The basis,
But
sorry to interrupt, the basis
the
of which...
actual, yes.
I'm sorry.
But the actual decision of setting aside applies to the tariffs for the 2004-2005 year. But the principle for the setting of the principle that can be extracted from her decision should apply to the later tariffs.
With respect, yes, and if I can pick up on that, Justice Tron. So when it comes to, in fact, we talk about the principle, and with respect, we agree with that reasoning. When it comes to the practicality, what the minister couldn't say is, I'm going to set aside all further tariffs for the next year and the following year. Say that in terms, because she doesn't know what that means. And notionally, Merafong might have in fact reduced the tariffs. We don't know. She didn't know at that stage. So we've got to freeze frame that. And that's the point. She could only make that decision. It would only impact on that what was before her. But the principle of applying the Water Services Act does not stop. And I think that's what
I just have two more questions, Chief Justice, if I may proceed, or
yeah, proceed and finish.
Thank you, Chief Justice. Is the applicant saying that the setting of tariffs is a condition?
Yes, it is, Justice Tron. It's one of the conditions.
What supports that it's a condition?
Yes. If we can refer you to the Water Services Act, Justice, and I dealt with this very quickly, and I apologize. It's Section 4 of the Act. And what we find in 4.1, Justice Tron, it's headed Conditions for the Provision of Water Services. Once again, this is transitional, and water services, which is, we're talking about potable water, must be provided in terms of conditions set by the water services provider. And if we can then refer to Section 4.2c, what these conditions must provide for is technical conditions. The second point which is made is Roman 2, the determination and structure of tariffs. And structure is perhaps, if I might just pause there, the structure of tariffs is important because underlying that is the basis on which the tariff decision is made with reference to the principles of the Act.
Because what the confusion that I have, Mr. Graves, is aren't various conditions taken into account in order to reach a particular tariff?
Various features, I would put it, perhaps if I could put it that way, Justice Trump, various features are taken into account to determine what the conditions are, which would then include the question of under conditions, include the tariff. And that's what the minister dealt with. That was what was before her. And the letter that I referenced in the questions from, I think it was Justice Majid, where Merafong comes out and says, we decided not to do this. The minister doesn't reference that directly, but what she does say, doesn't reference the letter, but what she does say, Justice Turon, in paragraph 2.1, she says the conditions opposed, she differs with them, the tariff increase of 62% with no value added as unreasonable. That's her finding. And that finding that finding stands. Whether it should have been challenged, well, that didn't happen. But the no value added must, if we look logically, have included a reference or had in mind the reference to what Merafong had told her. I don't know if I've sorry.
Yes, you have. Thank you, Mr. Graves. What is the applicant's position on whether or not the tariffs fall within the exclusive jurisdiction of the municipality? Yes. And whether the minister acted ultra vires in interfering with the municipality's decision?
Justice Trump, we'd say that the answer to that is found in the Constitution, section 1557. You'll be familiar with that. And what it says, just for national government, subject to section 44, and we don't have to worry about provincial, have the legislative and executive authority to see to the effective performance by municipalities of their functions in respect of matters listed in Schedule 4, which is one of these, by regulating the exercise by municipalities of the executive authority. We would conjoin that, Justice Tron, with section 229, which deals specifically with tariffs. It's 229 of the Constitution, sub 2. It says the power of a municipality to impose rates on properties, surcharges on fees, that's what we are concerned with here, for services provided for on behalf of the municipality. And sub B says may be regulated by national legislation. We say that the Water Services Act is exactly that form of regulation. It's regulation, but in the term declared by the Constitutional, by this court, in the certification judgment, which in fact made it clear that it was an oversight function. It's not a primary function. The minister doesn't determine. This court in the Ongeni decision, they said the minister doesn't have the right to determine. Here she's not determining the tariff. She's in fact acting in a regulatory capacity. That's what our submission is. It is subject to sorry, I just dropped.
Yes, no. Thank you, Mr. Graves. Thank you, Chief Justice.
I propose that we take the tea adjournment. It's 11:19. We can come back at 25 to 12.
Thank you, Chief Justice.
Is my arithmetic correct? Is that 15 minutes?
It seems to be.
Justice Mahlanga is laughing at me, suggesting that it's off. 25 to 12.
Thank you, Chief.
Court will adjourn until 11:35. Please note that during the adjournment, you are welcome to switch off your video and mute your microphone, and then rejoin with the video and sound when the hearing recommences at 11:35. Should you exit, you may use the same link to rejoin the hearing.
All right. We're just waiting for Justices Madlanga and Golapen.
Thank you, Chief Justice.
Oh, there he is. There they are. All right. Zunaid, are all counsel back online?
Justices of the Constitutional Court, all counsel are online.
All right. Thank you, Mr. Mango. Are there any further questions for Mr. Graves, colleagues?
Yes, Chief Justice. Mr. Graves, like Justice Majid, I too am concerned about the large amount involved here, in excess of 200 million rand, if I'm not mistaken. Assuming that we are with you, since this is a constitutional matter, under section 1721B, we have a very wide discretion, and where that might take us, your guess is as good as mine at this stage. But I just want to posit one possibility. An order for immediate payment has the potential of causing serious cash flow problems. That's an objective fact. I don't think we even need to go so far as to say the municipality ought to have put this on affidavit. Yes, it's desirable that it should, but I think it's an objective fact that we should consider. And indeed, I think that's the point Justice Majid was making as well. Now, here's what I want to posit. Would it be open to us at all to rather say, as one of the possibilities under the wide discretion, Anglo Gold should be credited for whatever amount, whether the amount in excess of 200 million or whatever amount, and then its liability should then, going forward, be deducted from the amount it has been credited with. Your response?
Yes, Justice.
It's still the same. It will still be the same amount, but at least it won't possibly or likely cause cash flow problems.
Justice Majid, the first point to make. Sorry, Madlanga. Sorry, Justice Madlanga. The first answer is the court does have that that wide jurisdiction in terms of 172. We don't suggest otherwise. As far as the practicality as an alternative that you raise, I understand, and I'm looking across at the client representatives as a second prize, and understanding the concerns of the court would certainly be an alternative. And it's not a question of negotiating about this. It's better than not getting anything. May I just say this, not to put a spoke in the wheel, Justice Madlanga. What we would hope to avoid is, as I think the Justice said, another 20 years of litigation. So we would hope that whatever, if there was something, it would have to be on a manner that wouldn't immediately in the first month lead to a dispute. But as far as that certainly is, it's a large amount of money. And I know that my client, Golden Core, has thought about this. It hasn't reached any decisions, and we don't want to go have a judgment that requires us to negotiate again. But sorry, a long answer to a short question, that is within the authority, and it would be something which we would understand if the court had that. It would have to take into account, I'll just make the point, the 126 million which is on the papers is not the entire amount. That final amount is not before the court, but it is, it's capable of monetary calculation. So our answer is that would be an alternative. Thank you, Justice.
Thank you, Mr. Graves. Regarding the constitutional challenge, that is the invalidity of, is it section 8.9?
8.9.
Yes, you seem to rely quite strongly on this court's judgment in Merafong 1. I have problems with that because that related to a challenge that was brought in those proceedings. Yes, in the present proceedings is still a challenge of the validity of the same section, but now brought in the second round of proceedings, as it were. So I don't think what this court said in Merafong 1 would of necessity apply in that different challenge. But for me, more crucially, right at the end, this court said the constitutional challenge would only have come to the fore if there was a holding that the minister does indeed have the power, which this court never decided. So it says in so many words that this is a matter, therefore, that is the constitutional challenge that should be decided, if I'm not mistaken, quote unquote, later. So I think your reliance in that first judgment is misplaced. Your comment?
Yes. Thank you, Justice Mlaga. The point that was made in Merafong 1 was, and what you've articulated with respect is entirely correct. But what was curious about the point, the constitutional challenge, it had not been raised in the Supreme Court of Appeal, and it was not frontally raised before this court on the previous occasion. I'm just looking for the
yeah, I think the difference was it was raised as part of what was litigated, but never argued at any of the stages, including at the Constitutional Court. And it was the Constitutional Court that dug it out of counsel for Merafong. And then the only response they proffered was, it's there in the papers, without arguing it at all. That's the context. I'm aware of that context. So your response to my question?
Yes. So Justice Mlanga, the point was not, let's assume that it was in fact, and I accept for argument's sake, that the point had been raised, albeit conditionally, whatever the case may be. The point is that the finding of the Constitutional Court in Merafong 1 is that it should be decided later, as with respect you've correctly indicated. Now, what did that require? Well, first of all, we've got to look at what had been raised at the first instance, and we find this, I've already referred to it in paragraph 66 of the judgment, where the majority said the order did not seek the setting aside of the ruling, but a declaration that she had no statutory or constitutional power. Now, that is not, as we read it, and bearing in mind what was said in those previous proceedings, it was not a challenge to say strike down section 8.9. It looked at the power of the minister within the confines of that section to in fact make a decision. What was sought in the new, and I'm just going to ask my colleagues to pull that up, the notice of motion, which was sought to be introduced in the High Court before Justice Stradle, was in fact, what volume? Volume 1. Yes, so we find that, sorry, Justice Mazanga, volume 1, we find that at page number 5. 5.1. Yes, sorry, it has been included, yes. So we find it in volume 1 of the record before this court. There we find that it was, the date on it is the 26th of July 2021, which I think was the day before. And what we find on page 5.2 it is declared that Section 8(9) of the Water Services Act, as amended, is inconsistent with the Constitution, invalid and set aside. Now, the difficulty we have with that formulation, is that nowhere in the founding papers is that case made out. And I can just, if I can answer it with reference to Merafong's papers. What is set out, and it refers still in volume 1 to the founding affidavit, it's page 43, which is headed Merafong's essential grounds of review. And we find in paragraph 10.1, we refer to references to the minister acting as a administrator, we've got reference to the decision, we've got reference to the municipal services, etc. There's an oblique reference in paragraph 10.4 to section 2291. But what we found importantly in page 45 in paragraph 10.6 is that Merafong says the minister had no power under section 8(9) of the WSA, or indeed the statute as a whole, to make the decision, and we emphasize that she did not interfere. She acted ultra vires in this regard. And there's a review sought in terms of pardon. That is not, and acting ultra vires is not with respect, and I don't, Justice, know that. It's not, in fact, it assumes the validity of the statute. And that is the theme that is, in fact, continued. We find other instances, but that's perhaps the most striking one, Justice. So that is our answer to the constitutional challenge.
I have a difficulty with it, a serious one too. The question whether this section is invalid, when you look at Merafong's argument, is founded on a purely interpretative exercise. It's an interpretation of the provisions of the Constitution, and then looking at the impact they have or possibly have on this section. So this has nothing to do with factual averments or anything like that that ought to have been made in the affidavit. So for that reason, I have difficulties with that reasoning. You are well aware, as I am, for example, on a different scenario altogether, that even with regard to legal questions being raised, not at first instance, but on appeal, the jurisprudence, even in pre-constitutional times, but the Constitutional Court has said the same thing as well. A purely legal point can be raised for the first time and be adjudicated by a court of appeal, as long as it does not cause prejudice to the other side. Prejudice, of course, not meaning that, oh my God, because this point has now been raised, I'm going to lose the case. That's not the prejudice envisaged. So I just don't understand then why something that, in my view, is purely legal could not have been raised in the manner that Merafong raised it here. At first instance, I would have understood, for example, if Anglo Gold had said before Judge Stradom, no, we are prejudiced, do not allow them to raise this point, or because we are prejudiced, let us postpone at their cost to afford us an opportunity to prepare for this legal question. That's not what has been said here. You are arguing a presumptively legal position, which I feel is totally wrong. Your response?
Yes, thank you, Justice Mulaga. The question of prejudice is linked, we would submit, to the question of whether there is a factual context which should be considered. In our respectful submission, it's not purely, and cannot at this stage of proceedings be purely a question of looking at the section and saying, does this, is this constitutional or not? The court is familiar, of course, and it's been referenced by you now, Justice Malanga, to the ability of a court to raise purely matters of law. That's the exception. It's the exception that is articulated in the judgments, and we refer to, I think it's Phillips. But the point is this, that to ask for that to be determined without that factual context, and it always has interpretation, now we know, has a factual context, we would say would be problematic. The second point we make in that regard is that striking down Section 8(9) leaves a situation, it makes the Water Services Act for certain purposes almost, it makes it difficult to implement. And we refer to the following. How does Section 63 of the Act, what is the impact on that? We say it does have an impact, where it says the minister must monitor the performance of every water services institution to ensure compliance with the norms and standards. Now, that can no longer be done, certainly through the appeal power. And the Act must, in our respectful submission, contemplate that. So there we run it. Merafong hasn't considered that. The other point that is we raise, and we deal with this incidentally, Justice Madlanga, maybe just reference this. It's in paragraph 71 of our written heads. The other difficulties apply when it comes to the provisions of Section 4. So tariffs that are imposed must be reasonable. But if there isn't an ability to manage that, to regulate the reasonability of those tariffs without having to go to court on every occasion, well, then there's something that becomes, it in fact creates an aura of litigious certainty within the application of the Act. Section 8, which I've already references, and that once again refers to the approval subject to reasonable conditions. Now, once again, if there isn't some form of ability to regulate, not to take over, but to regulate that authority, that power which a municipality has, it means that the user of water is left in the situation that it depends on the whim of the municipality. So one municipality will say, yes, I take your point. Another one will say, as Merafong, I'm not interested. So there's no internal regulatory process. Once one takes out the appeal power, it has consequences throughout the Act. The norms and standards can no longer be regulated and policed other than going to court. And that, in our respectful submission, is the difficulty which is faced by the late challenge that was raised by Merafong. Sorry, just bear with me. Yes. We refer in this regard to the my vote count. The court counts. It must be set out, and save in exceptional circumstances. And we would say in our respectful submission, this cannot be. This particularly in the light of the circumstances which attend this long-running case, it can never be said that this is a pure legal point. And we say that with deference to the point that you've raised with me. Simply can't be. There is a rich factual context which lies behind this. And knocking Merafong, apart from being late, has not thought of the consequences. It has said nothing. How do we manage this? How does this process of regulation, which is in fact articulated in the Water Services Act? And the final point, if we can perhaps raise this, Justice Madlanga, is that the preamble to the Water Services Act, the final point that is made is it confirms the national government's role as the custodian of the nation's water resources. Now, what comes with that serious duty, we would submit, is the process of providing for and permitting national government to, in fact, see to, as what we found in 1557, and in fact to regulate. And we find that to be a strong indication that ministerial input is required. And I go back to the point, I don't wish to repeat myself, but that must be found, must be dealt with in the factual concept. I'm sorry, I've gone on too long.
Yeah, you have, thank you, Mr. Grave. You have thrice referred to the need for a factual context, and you actually end with it. But not once have you said, and here is the nature of a factual context that would have been relevant here. So I continue to have my difficulty, and I just do not see, to me, this remains a purely interpretative exercise, which you engage in by looking at the provisions of the Constitution and then Section 8(9). I just don't see what and if you look, for example, at even at the High Court judgment, which is relied on by the Supreme Court of Appeal, if you look at paragraph 24, page 888, volume, what's the volume? Volume 9.
Volume 9, yes, as you please.
Yes, all that the High Court says is to refer to the need that the point must be raised pertinently with full and proper motivation. The constitutional challenge raised by Merafong was more in the context of a legality challenge. Well, that's not the case. The amendment in so many words seeks the invalidation of Section 8(9). The burden of an applicant who wants to attack the constitutionality of an act of parliament will include satisfying the court that the subsection cannot sensibly be interpreted in a manner consistent with the Constitution, but must ineluctably be declared to be unconstitutional. That's wrong as a matter of principle. The Constitution, Section 39(2), puts the obligation on courts and tribunals and fora to interpret in a manner consonant with the Bill of Rights. So it's an obligation not on an applicant. That's wrong as a matter of constitutional principle. And also, even outside of the Bill of Rights, when you interpret statutes, you must do so in a manner that is consonant with the Constitution. Hyundai says so. It refers to authorities in America that don't even have a provision similar to our 39(2). So, and in that context, the context of Hyundai and this principle, that too is a burden that lies with the court, not an applicant. So, short point, there's nothing even in the High Court judgment, and the SCA then just proceeds to say they accept what the High Court says. And then in paragraph 25, they don't say much. The Supreme Court of Appeal doesn't say much. So my point says this is a legal question. What more by way of factual averments ought to have been said?
Just briefly, I don't want to repeat it. We would submit, and if there's said that there's no burden on the party seeking to set aside, we would
perhaps just to limit the possibility of repetition. You also said you referred to the need for testing the reasonableness. Otherwise, everything would be nightmarish with unending litigation and so on. You are able to say that without a factual context, that actually buttresses my point that this is a legal question. So you could have argued what you are arguing now as a legal question. And indeed, you are arguing it as a legal question. And then also you say, let me just see. You mentioned the need for the factual. What else? And you also refer to what the preamble says. That too is a matter or a question of law. Okay, yes. You may continue.
Sorry, Joseph Slugger. Perhaps with deference, the suggestion or the notion that Anglo Gold should have put up the factual context inverts in our respectful submission the burden, the duty that should in fact lie on a party. You come and you say we want this to be overturned. Of course, it has a pure constitutional aim, but you have to do so within some kind of context, or say there is no context that can ever be. We weren't called upon, my client was not called upon to deal with the various practicalities. And I can't tell you what they are, Justice Madlanga, because they haven't been raised, but it's because it hasn't been triggered, we would say, by Merafong. And finally, the decision or any approach that were to say this is purely a legal matter, it's a matter purely of interpretation, we would say would disregard some of the features of this litigation which have gone before and which have brought us on a longer, wrong route. So we say respectfully that there is a factual context. I can't say to you sensibly what it should be, because it's not on my papers, and that would be wrong.
Thank you, Mr. Graves. Thank
you.
Very
I'm
much.
grateful to you, Justice.
Chief Justice, may I?
Yes.
Mr. Graves, just in the context of the Water Services Act and taking into consideration what Justice Madlanga just said, and raising it as a legal point, if we just look at the Water Services Act, the long title, it says to provide for the rights of access to basic water supply and basic sanitation, to provide for the setting of national standards and of norms and standards for tariffs, to provide for water services, development plans, and so forth.
Yes.
Now, my problem is, even if one should say Section 8(9) is unconstitutional, as you've already pointed to certain sections of the Act, that may then be difficult to comply with. If one looks at the monitoring that you've already indicated, the monitoring role, and then if you look at Section 9, 3D, which again, the one starts, the minister may from time to time prescribe compulsory national standards relating to. 3, in prescribing standards under subsection 1, the minister must consider any norms and standards for applicable tariffs for water services.
Yes.
So if we just strike 8, 9 to you, the minister may on appeal, we will be encountered with a difficulty, because 8.4 will mean nothing, because what is the point of having an appeal, right? Secondly, if we look at the purpose of the Act, the preamble, as well as the long title, plus the Constitution, it would seem to me, and I understand that water as a national resource requires some intervention by national legislation, and that may be the reason why the Water Services Act is set out as it is. So for a moment, let's accept that the constitutional challenge has been properly raised. Can't one just go on an interpretive quest and look at the Water Services Act and say, well, even if you strike that specific section down, it's going to create uncertainty, or am I wrong?
With respect, Justice Tolma, you've put it more clearly than I did in my debate with Justice Madlanga. That taking a textual interpretive approach with respect what you've articulated is correct. There is a tumbling down, there's a knock-on effect. Taking out the appeal power, which comes right at the end of the process, it doesn't come in early. Taking that away impacts we would say adversely, a number of features and functions of the Act, including the important position, as you've articulated, of national government as the custodian, and this importance of standards which are not only related to tariffs, because the appeal power, if taken out in 8.9, the decisions that may be taken are not restricted just to tariffs. So it could be the conditions of supply, that a municipality doesn't have to provide clean, potable water, which is a constitutional obligation. So with the greatest of respect, what you've articulated is, we respectfully submit that is correct, and we align ourselves with that. It would have greater consequences than simply taking out a section. And perhaps what I've done is inadvertently conflated that with the factual matter. But once you are going to have a debate about, or a decision to strike down a section of legislation, you have to look at the impact of that, and that hasn't been considered here.
Thank you, Mr. Graves.
Thank you, Justice Coleman.
Colleagues, any more questions?
Chief Justice, I just have a short question. Thank you. Mr. Graves, you commenced as part of your opening by referring to the principle of legality, and that's an important principle because, one, it discourages self-help, but secondly, it sets the boundaries of the powers of decision makers and the boundaries of the decisions they may take. It is also a tried principle that the grounds for a decision is distinct and separate from the decision itself. And in this matter is the problem that you face, not that even though the minister's grounds for reaching the decision seem to have permeated the manner in which the municipality continued to act, and as a matter of fact and as a matter of logic and as a matter of common sense, it would have the result that it would call into question, at the very least, the lawfulness of those decisions. In the years subsequent to the year for which the minister exercised her appeal powers. But the consequence of all of that is that those decisions remained lawful until set aside. And is that not the difficulty that this court is confronted with now? Because to impute those grounds, valid as they may be, to subsequent decisions taken in subsequent years without those decisions being challenged would be an act of self-help, would it not?
Justice Colopin, can I just understand, when you speak about the decisions that are taken, are we separating the minister's decision, if I understand it, from the subsequent decisions or actions by the municipalities? Do I understand correctly?
Correct, Mr. Graves. The minister took a decision in respect of 1 year only.
Yes.
The municipality took subsequent decisions, but in those subsequent decisions, they may have acted unlawfully by ignoring, as it were, the bases on which the minister relied on for a first decision. But there was no challenge to those subsequent decisions. And is that not the difficulty that you may have to confront?
Yes, there was, with respect, there was a subsequent, there was a challenge to those subsequent decisions. I'm just looking for, trying to locate the amended notice of motion. I've created havoc in my own life here. If you'll just bear with me, Justice Colopin. Yes, it's found in volume 4. This is the amended notice of motion, commencing at page 329. And if we can turn up page 330. I'm referencing the alternative relief which was sought, which has remained in our notice of motion, paragraph 7. That's to review these decisions, either in terms of party or legality. The decision made on 31 May 2004, that is the original Merafong decision to amend the tariffs. And we go on as promulgated in the Gazette of 22 June 2004 and all such resolutions subsequent to the extent that they impose tariffs or surcharges on the supply of water for both industrial and domestic purposes. Now, we challenge that. It's not an oblique challenge, it's in fact an alternative challenge. And that challenge which we raised, Justice Colopin, is in accordance with our approach, which I've debated with the justices earlier, and that is that the not having followed the proper prescripts correctly, and more importantly, not having followed the minister's decision as it was given. And if I might just pause there was an easy remedy for Merafong. It could have reviewed, it could have started at the right stage. It knew it had to review, and in 2006 it knew it did. So what has happened is we end up with what is more problematic because of a delay on the part of Merafong. But the challenge to those decisions was raised, and we say that that is founded upon the first. It's in fact the original decision made by the municipality, which in fact has set aside. So that doesn't stand anymore. The minister's decision doesn't set that aside on its own. And as the SCA said, it's not a court of law, but it makes a declaration that what should be done with that. And that is binding. It says you can't charge, let's take industrial water, because it's most of you can't charge a surcharge on industrial water. That's a binding decision. And any subsequent, and we find that in the schedule which we've provided, because it does charge a surcharge, because it charges a flat rate. And the rate that is charged for both domestic and industrial is far higher than the rate charged by Rand Water. That's a surcharge.
Was that all?
So just to follow up, so is your contention that the SCA was incorrect in indicating, well, it was correct in saying that the minister's decision was confined to 1 year, but it was incorrect in indicating that there was no challenge by the municipality to the tariffs imposed in subsequent years?
Yes, as to the second, yes, it was incorrect. And in fact, if I might just, Justice Colopin, with your permission, just refer to the, it seems to have been overlooked by the Supreme Court of Appeal. We find that in the order that was sought. We find that in the Supreme Court of Appeal judgment, it is captured. I'm just going to find it. Sorry, if you bear with me. Yes, it's found in volume 9, Justice Colopin, at 905. It's paragraph 70.
Okay.
And if you have that, it's paragraph 2.2, where the direction is sought that Merafong should comply with the minister's decision to render monthly accounts, etc. And that is then linked to paragraph, the negotiation point has gone, which is 2.4. It's linked to 2.5, where Merafong is directed to credit the account in respect of all tariffs paid and recovered for the supply of water for both water and industrial in excess of the rate charged by Rand Water, domestic and from time to time. And importantly, the last sentence, this will apply from the date of the minister's decision on 18 July 2004, date of this order. So that is, the answer to that is the SCA was wrong that it wasn't sought. As to the first part of your question, Justice Colopin, the SCA's finding focused, regarding the tariffs, focused on a particular tariff. And as we've argued before the court today, the tariff is but a consequence of the conditions that have been imposed. And the condition says you may not impose a tariff on industrial water. far as domestic, we say the same applies, but on the industrial, it's entirely clear. The negotiation process went nowhere. So we say that it was something that we did seek, and which the SCA, and I don't want to repeat myself, was with respect incorrect.
Thank you, Mr. Graves. Thank you, Chief Justice.
Thank you, Justice.
It does not appear that there are any more questions for you, Mr. Graves. Thank you very much. Mr. Motete, it's your turn.
Thank you, Chief Justice. Before I commence with my address, I would like to give some references, particularly to the question raised by Justice Majid, that there's nothing from the municipality regarding the harm it will suffer if there's repayment. Now, in the supplementary affidavit at volume 1, paragraphs 11.1 to 11.9, and this is at pages 47 to 54. The municipality deals with its difficult financial situation. It also, in those paragraphs, it deals with the living out allowances that are paid by the mines and lead to informal settlements, and it explains how any repayment will be catastrophic. But the High Court, also at paragraph 143, this is in volume 9 at page 836. It deals with those, the prejudice that will be suffered by the municipality. That is, of course, also when it assesses the delay point. It dealt with the prejudice also, so that is dealt with. Also, with regard to the constitutionality, because the argument has been that this point was never raised at the inception. Well, that is incorrect, because if we look at core bundle volume 1, the first, well, paragraph 2 of that notice of motion is at CB2. No, in fact, it's paragraph 3. It starts at CB2 all the way to CB3. The municipality there raised the constitutional argument. It sought section 8.9 to be declared unconstitutional. As to where in the affidavits it dealt with that, I can also give references, and that appears at volume 6. This is in its initial answering affidavit, which also served as a funding affidavit in its counter application. If one looks at paragraph 59, for example, it's volume 6, page 584. Paragraph 59 deals squarely with the constitutionality issue. But then it says from paragraph 9 that then for the reasons given above and those that appear in the overview of the relevant legislation that will be set out below, it would to that extent be unconstitutional. And if one then looks at what is dealt with as overview, it starts at paragraph 62 on the next page. All the way to paragraph 68. So we say it was properly pleaded and motivated in the affidavit. Also at paragraphs 5 of the very same affidavit, page 554 to paragraph 6.7. It is dealt with. All that the municipality did in the High Court in these current proceedings, all that it did, because the way it was initially raised, the constitutional point, it was conditional. All that the municipality did in the High Court in the second round was to remove the conditional aspect. That's all that it did. It did not raise a constitutional point as a new point. In fact, that is why even the majority of the Constitutional Court did not say the Constitutional Court was not properly raised. I mean, the constitutional point was not properly raised. All that they said is that it was not argued, and it can be argued later once the reactive challenge and the effects of the delay has been dealt with. And this is what we're doing. And that is why even the three judges of this court proceeded then to deal with the constitutionality point. So I thought I should give those references. But as to the points that I want to deal with, and I want to start firstly with what was pleaded by the applicant. Now, I'm using my reference here. In its amended notice of motion. And this is important to understand what is it that it attacked and why the SCA says it is only the decision of the minister that was sought to be enforced. Basically, it was a declarator that was brought by the applicant. At volume 4, page 329, that is where we find its notice of motion. It is quite clear, and my friend has addressed the court on this. It is quite clear that looking at paragraphs 1 to 6, all that the applicant sought was to enforce the minister's decision. And it identifies that decision as a decision of 18 July 2005. It does not, in those paragraphs, say anything about the consequent decisions. That we only find when it now introduces paragraph 7 of the notice of motion. It is only in that paragraph 7 where it says, it will also seek review of the subsequent decisions either under PAJA or under legality review. But the difficulty for the applicant, of course, is that what the SCA granted, as we understand it, is only the enforcement of the minister's decision, not the review of other decisions. And in fact, even in the court, one of the reasons their application was dismissed, we argued that for you to bring a review, firstly, you must identify the decision, then we'll be able to see if you've delayed in taking it. What is clear, what is common cause, is that they have never brought any condemnation or extension if they come under PAJA. They've never done that. Even if they come under legality, they have not explained their delay. Because from what they seem to be suggesting is that even the decisions taken on 1 July 2000, or at least June 2005, that is for the subsequent financial years, and the subsequent decisions, they say each of those decisions must be reviewed and set aside. This is what they sought in the notice of motion. It was a review. The SCA did not grant the review, only granted the implementation of the minister's decision. So that distinction is very important, because this court cannot even enter the review of those decisions, because it is not how what the SCA found, and it is not how this applicant approaches this court. So that is the first point that we wish to raise. But also, and most importantly, the applicant was not unaware that the subsequent decisions were in fact different. It was in fact, it says so in Core Bundle Volume 2, page 74. At page 74, and this is the meeting of 4 September 2007 no, sorry, I'm referring to the wrong one. The correct meeting is the one of 27 August 2007 at CB 73. That's where it starts. The justices, you'll note that Anglo Gold was also represented in this meeting. That appears at CB 73. But what I want to refer this court to is lines 23 to 24 of this page. Now, just as a context, in 2007, and it is common cause, Merafong introduced a flat tariff, both for industrial and domestic. And this is what the discussion was about. The court will see from lines 11 onwards, there's a reference to flat rate. So it was no longer as in 2004. It was not an industrial water tariff and domestic water tariff. It was a completely different addition, introducing a flat rate. But what the mines say here, they say, and if I may just read, it appeared that the mines had three options. So they were unhappy with the flat rate. And they say they had three options, namely, another appeal to the Minister of Water Affairs and Forest. That's one. And two, they say challenging the municipal water tariffs in court, or an approach to the Merafong City. So they could not have been mistaken as to the import of the decision by the minister. They could not have been mistaken. And as I've submitted, even the notice of motion is quite clear. They understood that initially all that they were taking is the execution of that decision. So with respect, and this adds on to our argument, and also what was found by the SCA, that the decision of the minister is limited only to the rates of 2004, 2005. It can't be referring to anything else. In fact, if one looks at that decision, it's at CB 19, that is core bundle volume 1. At paragraph 2.1, of course, it says that the minister says she differs with the conditions imposed by the Merafong local municipality, but she goes on to criticize the percentage that has been levied by the municipality. And at paragraph 2.4, the minister says she is setting aside the domestic water tariff, but the parties must go negotiate on the domestic water tariff. That tells us that the minister was more unhappy with the unreasonableness of the tariff in her own words, in a sense that it was 62%. And perhaps if the municipality and the mines had agreed to something, perhaps say 10%, maybe the minister would have been happy. But the point is, this must not be read as the minister saying the municipality must never, ever charge a tariff. It is about how much should be charged and what percentage should then be charged. But then you see that is important because we've got to see, and this has not been placed before this court. What then is the percentage of the subsequent decisions? Was it 62%? Was it 20%? Was it 10%? Was it unreasonable? We don't have that here, so it can be reviewed. Those decisions cannot be reviewed at all. So it is just to emphasize the point that the SCA is correct, and there's a point raised by the municipality right from the beginning that even if the municipality was wrong, the ruling of the court should be limited only to one financial year. It is so that each and every year on 1 July, there are new tariffs. That is the legislative scheme that governs local government. Each and every year, there are new tariffs, and there's a fresh resolution by the municipal council, a very deliberative process. And we've not been told what days are those, and how will even this review affect other resolutions that were taken, because the resolutions will not have related only to the water tariffs, but there would have been other tariffs. And the water tariffs may have been, for example, with 2007, it's a flat rate. It may have been for industrial and domestic without making a distinction between the mines and other industrial businesses. It may have been one tariff. How then do you delineate? And this is very dangerous if this order is to be made, because it's going to lead to further fights. The Anglo Gold did not bring proper review for each and every one of those decisions, identify it, and make submissions on it. It hasn't done that. It cannot rely on the setting aside of or the enforcement of the minister's decision and say, because of that, then there necessarily has to be a review of other decisions. That cannot follow. The second point that I want to deal with, our opponents in the supplementary practice note raised the point that we had not challenged the delay point, and as we understand them, we should not be raising it in this court. But with respect, that is an incorrect portion of the law, and in fact, Justice Madlanga has already indicated that where a point is pleaded in the papers, even though it's not raised, but it's pleaded, it is there in the papers, then it can be properly raised on appeal. And by the way, the main reason for the Merafong one to refer the matter back was so that Merafong can explain the delay and then seek review. It did that comprehensively in the supplementary affidavit. That point was argued, the delay point, it was argued in the SCA. And therefore, all the facts are here, all the legal points are here. There's no reason why this point cannot be argued. There's been various decisions of this court. I can refer to Bakhazen versus Napier and many others, where this court said the pleadings and what was raised in the higher court, it was very clear on the pleadings, and therefore the point could be raised there on appeal. But the reason why we raise this point, it is what the SCA finds in its judgment. That will be at paragraph 28. Paragraph 28 of its judgment at its volume 9 at 890. And this is where, because Merafong had raised the issue that the High Court had exercised a true discretion when it dealt with the issue of delay. And the SCA says the preliminary point is unavailing. I'm reading from paragraph 28. The appellate courts, including Constitutional Court, many times over, have considered whether the High Court reached the correct conclusion on the question of delay. That portion is entirely principled, and it goes on. With respect, we say this does not answer the question that was posed by Merafong, and in fact, indeed, it does not answer the question of law that is even asked in this court. This court, in Trancon, has set the parameters of what the Court of Appeal takes into account when it is dealing with appeal on the exercise of a discretion by a High Court. But more of more relevance is what this court said in Notiana. The Notiana decision, we've referred to it in our heads. What I want to refer this court to, just to give reference, it deals with at paragraph 40 and 41 of that decision, and this was the unanimous finding of the court. It deals with interference with discretion on appeal, and it deals specifically with the overlooking of the refusal to overlook the delay by the High Court. And it says our law vests in the court of first instance the discretion to condone a delay by an applicant in instituting review proceedings. The exercise of this discretion may not be interfered with on appeal on the basis that the decision was incorrect. Whether the appeal court would have exercised that discretion differently is irrelevant. But this is exactly what, well, it is what the SCA says should not be done. It says, and if I may continue reading from where I stopped in that judgment, after saying the position is entirely principled, it says, whether a court should entertain a review is a question of jurisdiction. A court is required to find that delay is unreasonable or that it may nevertheless be overlooked to permit the review to be decided. Then it says, which is against what Notwana says, that is not the exercise of a discretion requiring special deference by an appellate court. On the contrary, the appellate court must be satisfied that the court's power of judicial review can be exercised. Hence, the question of delay is a threshold issue as to which this court must be satisfied that the High Court redux came to the correct conclusion. It is for this issue that we now return. Our argument with respect is that the SCA got it wrong. The test should be the test espoused particularly in Notiana at paragraph 40 and 41. And for this reason, we say that the appeal of the municipality on that aspect must succeed. The court can just bear with me. Yes. If I may then move to the next point that, well, perhaps just to finish off the point and in relation to paragraph 41 is that the SCA could have interfered with the exercise of the delay by the High Court only if it found that it was not judicially exercised, whether on the facts or on the law. But proper analysis of the High Court's decision, it shows that it was a thorough exercise in dealing with the facts as to the delay. In fact, the High Court reaches a conclusion that it is not happy with the explanation by the municipality, but nevertheless decides to overlook it. It sets out all those facts. Even on the law, it set out correctly what the legal position is with regard to delays and so forth. The SCA could not, with respect, criticize the High Court for not exercising its discretion judicially. And we say both on the facts and on the law, the High Court was correct. It dealt with it correctly. Yes. And any doubt on this is dispelled by what the SCA says at paragraph 65 of the judgment. Because according to the SCA, all that it has to find was that the High Court was incorrect in its conclusion on the delay point. It says we conclude that the High Court redux was incorrect to overlook the delay of the municipality in bringing this review. The delay was both unreasonable and should not have been overlooked. So it says nothing about whether it was not judicially exercised or not. It simply says it was incorrect. It must be overlooked. Notwana says that is irrelevant, whether it is incorrect or not. Then I would like to deal briefly with the explanation for the delay, and then why we say the criticism against the municipality that its conduct was unconscionable is with respect unfair and must be understood in its proper context. The Constitutional Court, of course, in Merafong 1 did say that what municipality did, holding its hand on the tap, was wrong. We accept that. It said that. But it did not leave it there. It went on to say the municipality must now be given an opportunity. And I'm looking at paragraphs, at the end of paragraph 75. of that judgment. The last sentence says that, of course, was because Merafong was content to keep its hand on the tap. It awaited AngloGold's move, which eventually came in April 2011. So the court here was saying the municipality did not bring a review, did not explain its delay, simply because it was content to keep its hands on the tap. But the next paragraph, it says, but on remittal to the High Court with appropriate explanation in further affidavits, there may be convincing reasons for Merafong's approach. This may arise from the fact that it was advised, as its answering affidavit in the High Court averred, that it was entitled to ignore the ministerial ruling and compel AngloGold to pay the surcharge. Ordinarily, this would not be an excuse, but Merafong may urge the law was not clear. And that is what we've argued in our heads. I'll deal with that shortly. The reasons may conceivably relate also to
You
the
may
quality
want to start rounding off, Mr. Motebe. You have 5 minutes left.
Goodness. Okay, I will round off quickly. The point that I want to make is that after the decision by the minister, and we must recall the minister said parties must negotiate. There were lengthy negotiations, but there was an opinion at that stage by Mr. Nalani that the minister can withdraw her decision. What does municipality do? The record is replete with letters written to the minister requesting the minister for a meeting. The minister, and we have got no explanation from the minister in this court. The minister ignored all that. There are a number of letters, meetings arranged, the minister cancels at the last minute. Ultimately the minister says, don't go to court, let's negotiate further, but it never comes to anything. But we must understand that the Merafong was laboring under an impression that the minister could still withdraw her decision. That was an advice from Mr. Nalani. But on 16 April 2007, and this is important, the SCA has not considered this further advice from Mr. Nalani. Mr. Nalani, in that advice, he says, it's a very lengthy letter. It appears at CB 67, 16 April. In that letter, this is 16 April 2007. In that letter, that is where he advises that the municipality can ignore the decision of the minister because it's ultra-virus. So one must consider that. And in this letter, he sets out the history of how the mines and the municipality engaged in negotiations. And at paragraphs 14 onwards, he also refers to the agreements that were reached and the tariffs that were to be implemented from 1 July 2006. And he deals with that. He said, you agreed, there was an agreement to be signed, and yet you are still not paying. But the municipality can, at paragraph 27, that's what he says. Paragraph 14 and 27, 14 is CB 69, so, paragraph 27 is CB 70. Even at that stage, April 2007, he was still saying that the municipality could ignore the decision of the minister. And the High Court makes a point that if the 3 judges of this court in Merafong held such strong views against Odegras, how could municipality then be blamed for also accepting the advice by Mr. Nalani, at least in 2007, that it could in fact ignore the decision of the minister because it was ultra-virus. So in my 30 minutes, those are the submissions that I can make. I'll wait for questions.
Thank you, Mr. Mutepe. Any questions for council colleagues?
Mr. Mutepe?
Yes, DJ.
What is your, Mr. Mutepe? What
Yes,
is your
yes.
response to AngloGold's argument that the role played by the minister is actually envisaged in sections 229 and 257 of the Constitution, which would then put paid to Merafong's constitutional challenge?
Now, with respect, that is in our view incorrect, because Section 2291 is quite clear that Merafong can levy tariffs not only on the services that it's rendering, but also on those being rendered on its behalf. And that is a exclusive competence of the municipality. The minister may perhaps at some stage set conditions as to how tariffs should be dealt with, but then he must do that. Just like the minister can make regulations to say this is how the act is going to be effected. The minister can do that, but that is a different question. Whether the minister can interfere with the deliberative exercise of a municipal council where it sets tariffs in terms of Section 2291 of the Constitution, and of course the Systems Act. So we do not agree that the minister has any role to interfere with that. And we agree fully with the judgment of the minority in Merafong 1 in its analysis of Section 2291. I don't know if that answers your question.
You've addressed only 229. I thought the argument was also based on 257 as well, and I've asked you about 257 as well.
257 or 155 sub 7. I think the argument was on 155 sub 7.
That's how I understood it as well, Mr. Matebi. 155 sub 7.
Oh gosh, I'm sorry. Apologies. Yes, please address that, Mr. Matebi.
Yes, but what the minister was doing here, it says the national government subject to Section 44, and the provincial governments have the legislative and executive authority to see to the effective performance of municipalities by other functions in respect of matters listed in Schedules 4 and 5. They may have, and that's what the Constitution says, but it does not give them the appeal powers. And I think that is where the Anglo Gold gets it wrong. It does not give the minister appeal powers. They may, for example, in legislation, set out what the municipalities must consider before setting tariffs. They may do that in regulations. But it does not give them the power then to be an appellate body for those decisions of the municipalities. And this is how this subsection should be interpreted with respect.
Thank you, Mr. Mutepi.
Justice Chick.
Thank you, CJ. Mr. Mutepi, can you please help me? It's possible that I didn't really understand your submission. If you can just assist me. Mr. Graves argued that they had challenged the subsequent decisions beyond year 2004 and 2005. And he also, in his debates with the court, referred us to what a condition means, meaning that you may not impose a tariff on industrial water. Now, your submission, and which I would like you to really explain to me, and which I may have misunderstood, is that you said that the SCA could not grant any relief in respect of the subsequent decisions.
Yes.
And this is what I did not understand. And
yes,
yes, and on what basis were you making that submission?
Justice Chick, it was based solely on what is pleaded by Anglo Gold itself. And I prefaced my argument by reference to volume 4, page 329 to 331. That is the amended notice of motion. So what happened initially, they simply attacked they sought a declaratory. Merafong took a point in its affidavit that, but even if you are correct, your attack should be limited only to that year. In the reply, it is only then that they brought this notice of motion. They say, well, in that case, we will then rely on Paja, we'll rely on legality. But they did that by inserting paragraph 7 at page 330. So the point that I make, the High Court dismissed this application. So it did not grant any review of any of the decisions. It did not. The SCA, the correct interpretation is that all that it says is that Merafong was naughty in charging for levies on addition when the addition of the minister has set aside those tariffs. So insofar as that is concerned, it grants a declarator that Merafong, the Merafong levying of the levies for that year was unlawful because of the existence of the minister's decision. So it does not say, for example, what it was being sought at paragraph 1. It does not say that it is declaring that Merafong can never ever levy tariffs against the mines. It does not say that. Paragraphs 1 to 6 were purely to say the minister made the ruling, you must comply with that ruling. And it identified the decision under attack. That is 18 July 2005. The point I was making, and which was argued in the High Court, once you then say you want a review of the decision of say, end of June 2005, end of June 2006, and so forth, you identify those decisions, you set them out. And you even attach those resolutions and explain, because resolution by a municipal council, it deals with a myriad of issues, not simply the tariffs against the mines. And it may be, and as I've indicated, in 27, they introduce a flat rate for everyone without any distinction. The difficulty with granting a review of such a decision, when it has not been placed before this court so that it is assessed properly, is that firstly, you do not know what is it that you are reviewing. But secondly, if you say it's a review, then explain the delay. Because as opposed to the minister's decision, they would have been entitled to say, but implement that decision. But once they go over that, they say they are now bringing a review. Then they must, of course, satisfy the courts that if it's a legality review, they brought it within a reasonable time, and if they did not, they have explained the delay. And they asked the court, even if our explanation is porous, please overlook the delay. We don't have that. That is not done. If it was a partial review, because I say those decisions, and this is important, Justice Tikwi, because the subsequent decisions are attacked only in paragraph 7, and that relies on Paja or legality review. So we know if it's Paja, you need an express condonation or extension of the time frame by the court. Otherwise, this court wouldn't even have jurisdiction to entertain those, because there's not been an application granted to extend the time frames. If it's a legality review, as I've indicated, there still had to be explanation for the delay. There's not. We had to, the decisions had to be properly identified. They have not. So that is why I say it is very dangerous to accept the Anglo-Gold's arguments to say that the mere fact that the ministers, the SCA says, implemented the minister's decision, therefore it follows that even the subsequent decisions are reviewed and set aside. That is an incorrect interpretation with respect. It cannot follow. I don't know if that answers the question, Justice.
Thanks, Chief Justice.
Right.
May I ask Mr. Motepe about the delay, please?
Yes.
Mr. Motepe, you say that the SCA was wrong in finding that this was not the exercise of a discretion, and you refer us to Nochawa and to Trencon. Now,
that's correct. Yes.
Accepting for the moment that you are correct, That means that this court can interrogate whether that discretion of Judge Strydom was judicially exercised. Do you accept that?
The court can, of course, mirror more to deal with that exercise, but only as I've submitted and based on the test on those very limited basis. Was it judicially exercised? Looking at
Yes,
the
no,
facts.
we are
Yes.
saying the same thing.
Yes,
There's
no,
a
I
very
agree.
there's a very narrow room for appellate interference, and we
Yes.
know that that is whether the discretion was judicially exercised or not.
Indeed,
But the
Justice.
point is, when you look at the judgment of the High Court, page 836, in volume 9 to page 837, paragraph 143 onwards, it seems to me that Judge Strydom found two bases. He found the delay was unreasonable, but he said it should be excused, and this is the discretion that he's exercising.
That is
There's
correct.
there's two main reasons. The first, in paragraph 143, is the potential prejudice to the municipality, and you've referred us to this earlier about the financial implications. And the second is at 144. The court has considered, that's at page 837, the court has considered the fact that Merafong has acted illegally for many years by enforcing payment of its tariffs for water supply without setting aside the minister's decision. But in my mind, the finding of this court on the merits of the review application will trump this factor counting against Merafong. The illegality has been explained to some extent. Merafong was advised that it could ignore the minister's decision. Now, what are the principles in our law that is being applied here that a functionary, an official, can ignore a decision of a minister on its view, simply on its view that is incorrect? Is that principle of our law stated correctly?
No, Justice Majid, even the High Court was not saying the advice was correct. It says, it just says that the Merafong, and there's a paragraph that I want to refer to where the High Court says, if the three judges, and this is in reference to the Odikral principle. And remembering that this was in 2006, 2007, it was after Odikral, but before Kerland was decided. So to some, the law might have been clear, but to some, perhaps not. And in fact, we saw it in Kerland because three judges of this court differed on the correctness of that principle, that the act, even if it's acceptable to review, remains valid until set aside. We know that was in 2014 when there was still that debate. And all that the Justice Strydom says in the High Court is that if three judges of the High Court can still have strong views about the interpretation of Odikral, then it perhaps explains why Merafong would have accepted the advice of Mr. Melan. It doesn't say the advice was correct. Of course, it was incorrect in law. The advice was
Does
incorrect.
the judge actually say that in the judgment, or are you inferring?
Yeah, no. The judge actually said that. I made a note, but because I've moved on, I'm going to find it. No, the judge actually makes that point to say if the three judges of the High Court,
not the Constitutional Court.
No. This is the Justice Strydom in his judgment.
No, the Chief Justice is asking you, when you're referring to the three judges, you are referring to Merafong 1. You're referring
Oh,
to
yes. No, with that, I'm referring to Odikral first.
Yes,
he says, he says in Odikral, oh yes, it's paragraph 83 of his judgment. He says after analyzing the advice given by Mr. Nalan, he says the point of all this is that in my mind it appears reasonable for Merafong, acting on advice of Mr. Nalani, to have concluded at that stage not to institute review proceedings as opposed to the declaratory relief it was seeking in this conditional counterclaim. If a contrary and strong view is held by constitutional, well, it's supposed to be constitutional court judges, as to the legal correctness of Odikral, it is quite understandable that Merafong could have believed that it was not necessary for it to review the minister's decision at that stage. And this court would also recall that even in Merafong, a couple of years after Odekra, Merafong was still arguing that the minister's decision was ultra vires and could be ignored as a nullity. That was the sum total of Merafong's argument, even in 2016. So all that we say is that, yes, the advice was wrong, but Mr. Nalani could be forgiven when even subsequently 3 judges of this court in Kerala could differ so strongly on the interpretation of Odekra. And here, as to repeat, it was 2006, 2007 era. Odekra was decided, Kerala had not been decided. So with respect, the judge is correct in his analysis of the law on this point.
Now, I'm not so sure that I agree with that exposition there and the reasoning of the judge, but let's leave that now and move on. You referred me to this paragraph 143 in some passages, that paragraph 11, where Merafong sets out financial challenges. What I assume is that you saying this court must infer that the municipality will have severe financial pressure if it's ordered to make a repayment. Because nowhere does it say that in terms. Do you accept that? It never says in terms that if we are ordered to pay between 170 and 200 odd million, we will collapse or we will have budgetary problems and so on. It's an inference you ask the court to draw. I just want to make sure about that. You accept that?
Yes, no, I accept that. That is the inference that this court must draw, but based on the facts that have been set out in those paragraphs and what the judge also with respect found. And if one can also look at the letter of Mr. Nalani, I've already referred to this letter at CB 70, core bundle volume 1, CB 70. If I may quickly, at paragraph 23, I don't have to read the entire, but there he also explains the value add by Merafong, because one of the issues raised by the minister is that municipality is not adding any value. Anglo Gold from day one, that has been the stance even today. And he explains there that one of the things that happens, the mines will retrench people. These people reside in informal residential areas. It is the responsibility of the municipality to provide them with water, to provide them with services, and it needs these tariffs. So to obviously comply with its constitutional obligations. So there are those facts, but there's also the legal points that municipality is obliged to render those. The living out allowance, and this is common cost. The mine also says that the living out allowance that it gives to its employees has also inadvertently led to informal settlements around the mines. But it is the responsibility of the municipality to service those people irrespective. And therefore, this court, when it makes its order, it's got to keep that in mind, that the municipality has got this constitutional obligation to give those people water and, of course, other services. It needs these tariffs. And it is, the painful point is that the mines, of course, as I've indicated, from day one, their point has always been that, but you are not adding any value. But if that argument can be taken to its logical conclusion, it means even businesses, all the businesses can raise that argument. Even some of us can raise the argument that, but municipality, I'm getting water from granddaughter, but if you perhaps are not getting it direct from municipality. Therefore, why must you benefit anything? But there's a reason why the Constitution says municipality can, in fact, levy charges. Municipality needs those funds so that it can then render other services. To simply come with a strictly commercial argument to say you cannot extract even a cent from us because you're not rendering any value. That argument is with respect incorrect and ignores the constitutional obligations of the municipality and the Constitution itself, of course.
Mr. Motepe, I want to just conclude with one aspect which deals with this constitutional challenge. And for the moment, I'm assuming, I'm not convinced, I must tell you, but for the moment, I'm assuming that it was properly raised. Do you accept that the use of water is crucial under the Water Services Act because it affects the categorization of water and it affects the powers and competences that water services or authorities have? Do you accept that?
No, of course I accept that.
Now, you say the minister acted unconstitutionally in exercising powers of appeal under Section 8(9), and that section should therefore be struck down based on the based on the municipality's exclusive competence in the constitution. Do I understand you correctly?
That's correct.
Now let's go to Part B, Schedule 4 of the Constitution. I mean, it lists there. You don't have to have a look at it, but if you disagree with me, we'll have a look at it together. It lists the exclusive functional areas for municipality under electricity and gas reticulation, stormwater management, but particular water and sanitation services limited to potable water supply. We know that's drinking water, isn't it?
Yes,
Water for
and
domestic
water
use.
supplies only potable water, yes.
It's water for domestic use.
Yes.
Now the minister argues this before this court. The minister says, when the minister made that decision under Section 8(9), the decision was that you can't levy tariff increases for industrial water because it's unreasonable, so the 62%. But the minister didn't, that's what the minister argues here. The minister didn't make a ruling that that affects domestic water. All the minister said is you must negotiate further. So there was no overturning of a decision. And the minister's argument, therefore, is that your constitutional challenge is lacking because your exclusive municipal competence is restricted to domestic water use, not industrial water use. And so what do you say about that argument?
Well, firstly, like I've submitted, we've got to recall that what rainwater supplies is drinking water. It's purely drinking water. It's potable water. The mine may then decide to use this for industrial purposes and so forth. But what the minister says it lacks logic. You cannot say, I did not set aside your tariff and yet still say to the parties, go negotiate the reasonable tariff. You cannot say that. And in fact, that is the finding of the SCA. It says, by implication, the minister set aside the tariff even on domestic water because she believes that she had those powers to do that. So we differ with that interpretation. The minister, even in this court, of course, adopts that argument, despite the fact that the SCA found to the contrary, and yet it says it is not taking side. It is simply abiding. We'll hear what the minister has got to say so that we understand fully. But the minister cannot say that. In any event, Section 2291 is clear. It does not matter. It does not matter that it is domestic water tariff or industrial water tariff. It does not matter. Municipality is entitled to levy a rate because somebody else is supplying that water on his behalf, which is rainwater. And this is what Section 2291 with respect authorizes. So we disagree with what the minister says. And in fact, the mere fact that even in this court, the minister holds this view, it shows the danger of this section, that the minister still believes that she can interfere with the executive or legislative functions of the municipality. The minister is not limiting herself to saying, look, I'm going to set out norms and standards, you must comply with them, or conditions that you must comply with them. She's not just limiting herself to doing that. She says, I will even come and tell you that you cannot impose a tariff of this nature. And we say that is wrong. The minister can set norms and standards, can set conditions. We will then have a look at those norms and standards to see what the municipality has done. Is it in compliance with the conditions set by the minister Is it in compliance with the norms and standards? And we find that it is not, and the court sets it aside. But it's for the court. The court will then deal with it and set it aside. But the section as it reads, and the mere fact that the minister believes, even now, that she can tell the parties that go negotiate what in her view will be a reasonable tariff. It supports our point that this section cannot remain as it is. And to answer also on what, or before I go to that point, I don't know if I've answered your question, Justice.
Yes, I don't want you to repeat yourself. I mean, you're saying the same thing over and over. Are you adding something new?
Yes.
Mr. Motepe, may I ask that you add the something new after the lunch adjournment?
Indeed.
I propose a lunch break of 30 minutes only. So that would take us to 1:45. Okay. Is that
Thank
fine?
you, Chief Justice.
All right.
Yes,
Thank you,
that's
Chief.
fine.
1:45 then, quarter chance.
Jesus.
Court will adjourn until 1:45. Please note that during the adjournment, you are welcome to switch off your video and mute your microphone, and then rejoin with the video and sound when the re-hearing commences at 1:45. Should you exit, you may use the same link to rejoin the hearing.
Mr. Mango, is everybody back?
Yes, Chief Justice, Justice of the Constitutional Court, all counsel are online.
Thank you. Are there further questions for Mr. Mutebe, colleagues?
I was still busy with him, Chief Justice. Thank you.
Yeah.
And I also have questions after that, Chief Justice, please.
Right. Let's carry on.
Mr. Motepe, were you done with what you wanted to add, or can I go to my follow-up?
I simply wanted to add, and in line with what was raised by Justice Tolme, that if the section is declared unconstitutional, the minister, of course, can always be given an opportunity so that the order is suspended, and then the minister is given an opportunity to amend it. As to how much time is needed, the minister will have to tell the court.
Yes,
That's all I wanted to say.
Yes. Well, thank you. I must tell you that I find it difficult to understand how, with water being a national resource, and Section 1557 pertinently saying that national government must exercise oversight and regulate the exercise of the functions by a municipality. That's generally, but in terms of tariffs, fiscal legislation, but pertinently in 2291 says that national, in Section 229 says national legislation must can make provision for this oversight. How in the norms and standards, you say the minister interferes if in terms of the norms and standards, the minister doesn't set the tariff, but says the tariff increase is unreasonable. I must tell you, I find it difficult to understand how you say the minister acts unconstitutionally, bearing in mind 1557 and Section 229.
The point that I made is that the minister is at liberty to set norms and standards for tariffs. She's at liberty to do that. But what she cannot do is to interfere with the fiscal powers of the municipality, because that's what she does when she interferes with the municipality setting tariffs. So what she can do, she says, here are the norms and standards. You can't charge tariffs in this manner, and it's written there, everybody can read. And of course, if the municipality goes against that, then it's acting unlawfully. There's no issue with that. But all that we say is that she cannot interfere with the fiscal powers of the municipality, because that's what she's done here. They set the budget and they said these are the tariffs that we need. She says no. So that's the argument.
Yes, no, I hear you. I wonder how would she enforce those norms and standards if you are non-compliant?
The same way that parties will enforce non-compliance with regulations, for example, made by a minister, then the parties go to court.
Yes.
It is not the minister who says, you have not complied with my regulations, therefore it's unlawful. You go to court. It's a similar situation.
Yeah. And that's exactly what you didn't do, the municipality. You didn't go to court. Because you see...
No, of course not. No, we can't run away from that, but we've tried to explain why.
No, I want to go to your explanation. Oudekraal was decided in 2004. Do you accept that?
Yes, that's correct.
And in Oudekraal, that was confirmed in Kirland. Basically, in Oudekraal, I'm not going to read the whole thing and in Kirland. Basically, in Oudekraal and Kirland, but let me confine myself to Oudekraal, because you says Kirland came long after the fact. In Oudekraal, the SCA emphasized why public officials cannot simply, without going to court, ignore decisions, because it would lead to administrative chaos. Now, you saying we should, the High Court was correct in excusing this illegality and the delay from 2006 to 2011 based simply on the fact that you followed wrong advice. Does that cover the whole 2006 to 2011, you say, of the delay?
It covers the period up until the municipality now started implementing its tariff in terms of its credit control policy. Justice Majid would recall that the letter of 16 April 2007 that I referred to, that's when the attorney for the municipality explained to DRD Gold's attorneys that the municipality is entitled to ignore the decision of the minister. It was only in September 2007 that it then enforced the tariffs. And we must bear in mind that this was on the 4th financial year. So
Sorry, may I stop you there, because we tend to go on too long. I mean, no disrespect, but surely the delay must be reckoned until the time you bring the review application, which is 2011.
Until the time we bring the counter application, but that is what the High Court did with respect. It found that the explanation was porous. There's no running away from that. It was unhappy with the explanation to say it doesn't cover the entire period, but still exercising the principles set out by this court, including in Buffalo City Municipality, among others. Then it then decided to overlook the delay.
Yes, I won't take it further than that. Thank you, Chief Justice. Thank you, Mr. Motepe.
Thank you.
Justice Drone.
Thank you very much, Chief Justice. Mr. Motepe, if I could go first to a subject that was also raised by Justice Majid, and to follow up. If we look at section 2292 of the Constitution, and it says there, the power of a municipality to impose rates on properties, surcharges on fees for services provided by and on behalf of the municipality may not be exercised in a way that materially and unreasonably prejudices national economic policies. And if we read that with section 155, sub 7, the national government and the provincial governments have the legislative and executive authority to see to the effective performance by municipalities of their functions. Does it give minister an oversight function or oversight role as to how municipalities exercise the authority?
Justice Throne, as I think I was answering Justice Majid on that. The minister can exercise that function by setting norms and standards, or yes, norms and standards for tariffs. The minister is empowered to do that. The Act says the minister can do that. So there's no issue there. And that will be in compliance with all these provisions of the Constitution, so that the municipalities may not charge what will then be detrimental to the economic situation of the country and so forth. There's no issue about it. The issue is that does not then say she's got the appellate powers to interfere with the fiscal powers of the municipality as an appellate board, because that will be quite arbitrary. You have a deliberative exercise of the entire council exercising. They look at the budgetary controls, and then they debate, and then they vote on them, and they approve the policy.
I don't want to interrupt you, and I'm sorry, Mr. Motepe, but I am aware of the time constraints.
Yes.
If we look at section 155 sub 7, the national government has the authority to see to ensure of their functions. And we're not talking now about interfering. I think my connection is to turn my video off, and it may be better.
You broke off for a second there.
Yes, I hope that it's better. I hope that
we can hear you.
Better.
I can hear you.
We're not talking. Thank you. Yes, we're not talking specifically about national government interfering in the fiscal policies of the municipality. This is a general power, general oversight power to ensure that the municipalities perform their functions properly and within their mandate. And surely, if the minister is of the view that the municipalities are not performing their functions properly, this gives her the power to interfere.
Justice Tron, it cannot be, it's not a power that can simply rest on the minister to exercise arbitrarily as she sees fit. The point that I make, in the very same act, it says she can set norms and standards for tariffs. And once she has done that, that is how then she'll exercise this power, to exercise control, to say you cannot go over this threshold when you charge your tariffs. And there's nothing wrong with that. So we accept that the minister can in fact have control, but as to how she exercises that control. For the purpose of this act, it will be in the norms and standards for tariffs to say you cannot exceed this. But where she now goes to
yes, my difficulty with that argument, and I've heard you present it already, is that the Constitution does not say that that oversight function is limited to the setting of norms and standards. But I think we can leave it there, Mr. Motepe. I think you've made the point, and I understand the point that you make.
Thank you, Justice.
Let's go to, and I think counsel for the applicant referred to this case of Tabachewerul Forum. Just give me a minute to get to my notes, please. Where the court in effect said, you cannot continue to recover something that's illegal. The municipality was prohibited from recovering from the appellants in that matter amounts greater than the legally permissible limit, because the court said that was unlawful. If we apply that principle to this decision, to this matter, and we take the decision of the minister to find that the tariffs imposed by the municipality in the years 2004 was unlawful, why should the municipality then, subsequent to that, be allowed to recover what was declared as an unlawful amount?
But the minister, when she decides that 62% is unreasonable, clearly she's complaining about the percentage of the tariff, that is, it is excessively high. When she says the parties must go negotiate on the domestic water, again, she's clearly complaining about the tariff, that it is perhaps high, we must negotiate a lesser tariff. In subsequent decisions, what is the percentage of the tariff? Because then we must go, if this is the reasoning of the minister, then we've got to go. And that is why we say there was no attack on each of those decisions, because we don't know what percentage. As we sit here, we cannot with accuracy say the percentage in that particular year was this much. In 2007, the flat rate was this much. The AngloGold ought to have attacked those decisions individually and placed those facts before court. Because here we have the minister saying, here it was 62%. We have that. But what of other decisions?
Mr. Motepe, once again, I'm sorry for interrupting you. I'm not talking about percentage. I'm talking about...
I've lost you again, Justice.
Have you lost you, Justice Theron? She still appears on the participants list.
It might be my ancestors interfering on my behalf.
Justice Theron? All right. Anyone else with
yes,
a question?
please, Chief Justice,
yes,
follow up on that.
Oh, she's back. Your ancestors dropped the ball there. Carry on, Justice Theron. She's gone again. Go ahead, Justice Madlanga.
Thank you, Chief Justice. Mr. Mutepe, I'm not sure that I follow your argument in response to Justice Theron's question on section 2292. You dismissed it amongst others by making reference to irrationality and so on and so on. But I read section 2292 to say that the municipality's power may be regulated by national legislation. Why is a provision in the Act that says the minister has the power of review? Why is that not a matter of regulation and therefore within what is envisaged by 2292?
Justice Madlanga, the difficulty that we have with this section, it is up to the minister to then decide what is reasonable or not. We don't have anything that the municipality must go against to say, okay, when we set a tariff, these are the parameters set by the minister.
But reasonableness is not a new concept in our constitutionalism. You find it everywhere. I mean, even the Act made in terms of Section 33, for example, refers to reasonableness. Even the socio-economic rights refer to reasonableness, and probably you would find it elsewhere. So it means that the framers of our constitution expected our courts to be able to grapple with the notion of reasonableness. And in fact, courts have dealt with reasonableness even in other contexts, even in pre-constitutional times. So why should reasonableness suddenly become a problem when it comes to section 2292?
The only point that I wish to make is that, as Justice Madlanga says, it is for the court to ultimately make that ruling that this is unreasonable, not a minister.
But no, courts only come in when there has, for example, been unreasonableness in the exercise of powers by functionaries. So
Yes.
courts only come in at that late stage, but the exercise of the reasonableness power resides in organs of states, organs of state.
No, that I agree.
So what you are saying is not an answer at all.
That I agree with, that the state organs must exercise their power reasonably. And as to whether in the specific circumstances the exercise was reasonable, of course it will be a question of fact.
Yes.
But I do accept that the state organs must
so how does that lead to unconstitutionality of the section providing for regulating that which might not be reasonable? How does unconstitutionality come in?
The only answer, and of course I cannot take it any further, the only answer that I can give, and I've given before, is that the minister has got those powers, then he gives or she gives the parameters of how the municipalities must then levy their tariffs. Then we know once they exceed that, it's unlawful, because the minister will decide this is reasonable, and then she sets the parameters. But that is as I understand, or as we understand these provisions of the Constitution, she can then set those, no issue with that. But she cannot, on an ad hoc basis, decide that in this particular instance, I'm going to overturn what the municipality has levied.
Now
So
you are being fact specific. You are being fact specific. We have a legislative instrument that does something, or rather that provides for something which I think is regulation. And the Constitution provides for regulation. If that be so, where is the unconstitutionality? Because the power to regulate comes from the Constitution itself, and all that Section 89 is, or rather does, is to provide for regulation. Unless you say the exercise of an appellate power has nothing to do with regulation, which I would find astounding.
No, I can never submit that. The only submission
then you are close to left with nothing to.
I'll keep repeating myself. I'll keep repeating myself that it sounds, it is arbitrary to us for it to be left to the minister to say, in this specific case, this is unreasonable, this is reasonable. Except where she has parameters set, then we can all see what we're judging the tariffs against, but not what we don't even know how she's going to arrive at the particular decision. It all depends on her as an individual overturning what I may loosely refer as the parliament of the municipality, and that we have difficulty. But that is as far as I can take it, Justice.
Lastly, you heard me earlier when I was engaging Mr. Graves. I referred to the now well-established principle that says you must interpret statutes in a manner that is consonant with constitutional provisions in order to avoid readily invalidating them. But of course, there's a caution that you can only do that if you will not strain the language of the statute concerned. I think, subject to your submission, that an interpretation that is consonant with the constitutional provisions is one that says there's nothing the matter with Section 8.9.
Justice, in fact, I had a debate with my attorney on that, and I did indicate that, of course, if this court was to adopt the reasoning of the High Court, because the High Court found that the section is not unconstitutional, but it is how the minister interpreted the section. If this court were to then interpret it in that particular way, in other words, reading it down, then we will be happy with that. Then it will mean the section can be saved. So I've got to concede that point.
In which event there would be no invalidation.
Yes, which we understand, yes.
Thank you very much. Thank you, Chief Justice.
Justice Theron, not back yet. Any other question, colleagues?
I am here, Chief Justice. I will try once more, but I've also sent my question to Justice Majid in case I lose connectivity. As a precaution, I'm switching my mic off, my video off. Yes. My question, Mr. Motsepe, relates to the principle. My question relates to the principle that emerges from the decision of Tabachewu and why that principle should not apply in this case. The principle was that where the municipality had charged the appellant greater amounts than was legally permissible, it should not be entitled to recover those amounts. Now here, for the subsequent years after the 2004 decision by the minister, the municipality recovered amounts from the appellant that in terms of the decision, let's not dwell for a minute whether the decision was just for that year or lasted longer, but in terms of that decision was not legally permissible or was greater than was legally permissible by the minister's decision. Why should that principle not apply here, and why should the municipality not be allowed, or why should the municipality be allowed to retain the monies, the additional monies it has recovered from the appellant?
For a simple reason that in that case, as I understand, the municipality was being accused of charging more than what was legally permissible. In this case, what was found to be impermissible is a 62% charge by the minister. The minister found that to be impermissible. But that is only in relation to 2004 edition. We can't run away from that because we do not know what percentage.
I don't want to interrupt you again, but let's assume that that was the rate which the minister would have said for subsequently the minister would have said was impermissible, had there been a specific appeal in respect of that. Let's just assume that the minister would have said that the additional amounts was impermissible.
Justice Theron, I would, of course, we don't have those facts here, but I would still say those were distinct decisions, 2005 onwards. We cannot run away from that. I understand Justice Theron says we must forget that for a minute, but my answer rests on that the illegality ended, and that is how the SCA characterizes its findings. It's only related to that to that year. So the principle with respect cannot then and go affect subsequent year where we don't know what the percentage is to start with and where there's no appeal on that.
Let's divide this into two. Coming out of the minister's decision, the appeal by the applicants to the minister's decision, to the minister. First, there's a principle that emerges, a principle as to the tariff that is legally permissible. And secondly, a declaration as a direct consequence that the tariff that for that particular year was impermissible. Now, can we say that the principle exceeds beyond the 2004 decision? The principle, if we have to extract it, perhaps call it a legal principle, that principle emerges and from that decision of the minister, and that principle should be applied in determining tariffs subsequently.
But the problem with the principle, and I assume Justice Theron is referring to a principle that municipality should not charge a tariff where there's no value added. I assume that is the principle.
Yes.
But again, that applies only to industrial water. The minister herself says so, because she then says, so far as the domestic water is concerned, she's not saying you can't even charge for domestic water at all. She doesn't say that. She says you must then go negotiate what will be reasonable. And the parties have tried, it didn't work. So the principle cannot apply. And I've already said in 2007, that's common cause. There was then a flat rate. A flat rate meaning for domestic and industrial. So then how do you apply that principle when it comes to that? And that is why one cannot extrapolate a principle from this ruling.
Thank you, Mr. Motsepe. Thank you, Chief Justice.
Thank you, Justice Theron. Anyone else, colleagues? No. All right. You're excused for now, Mr. Motsepe.
Thank you, Justice.
Mr. Erasmus.
Chief Justice, may we...
Just confirming that you waived your protected time and allow the justices to... Okay, they can question you right away.
But may I just indicate, we would just like to make 3 succinct points, and it shouldn't take long. The first one is the nature of the decision of the minister and what the effect thereof is. And then the third point is a constitutional attack, both on the decision of the minister, but also against Section 8(9), because the two, for us, go hand in hand, and they are actually closely related in the facts of this case. If we just go first of all then to the decision of the minister, you'll find that in the core bundle 1 on page number 19, it commences. And the only point we would like to make and emphasize is paragraph 2.2 of that decision. Because what is clear what the minister had done at that point in time, she reminded herself that the provision of potable water is an exclusive municipal competence, and therefore she shied away from interfering with the surcharge levied by Merafong in respect of potable or domestic water. The effect of that, of course, is, and as also explained in the affidavit that was then later on filed on behalf of the minister, You will find that in volume 4 and pertinently on pages 402 and 403, you will see that it is then explained by the then acting Director General that what the minister did was not to set aside the surcharges on the domestic water. So it stayed there. So there was a surcharge imposed by Merafong, not overturned by the minister, and the effect of that, we respectfully submit, simply is that until that decision of Merafong is set aside, namely the imposition of the surcharge, then of course that surcharge was lawfully raised against Anglo Gold. But the converse, we say, apply insofar as industrial water is concerned, because there the minister made a clear decision, overturned, she varied the decision of Merafong, and she said that you are not entitled to charge or to levy a surcharge, and therefore the imposition of the surcharges by Merafong was therefore unlawful because it is not in consonance with the decision taken by the minister. And the upshot of all of that, because it might be of some assistance to this honourable court when they have to grapple with this 126 million rand, because as to how you should approach that, Mr. Graves for Anglo Gold already referred you in volume 4 to pages 338 and 339, and if we can just conclude this point to point out to the court what the practical effect is of the submission that we have made just in respect of the domestic water and the industrial water. If you go to page 338, you will see on the right-hand side of that of the A3 page, you will find there's a darker color, and it contains 6 columns. The second one from the left there, you will see it says domestic surcharge. That is now what we submit. Merafong could have, until such time as their decision to levy the surcharge is set aside, they could have levied. And if you go over the page to page 339 and you go to the second column from the left on the darker portion of that page, that is approximately 86 million rand. And if we now do the same exercise pertaining to industrial water, that's the second column from the right-hand side on the darker page, which we respectfully submit, Merafong should not have levied the surcharge, and that comes to about 40 million rand. And of course, it now depends as to what this court is going to do and how the court now in its whatever decision it's going to make, let's for argument's sake say it sets aside one but not the other, or perhaps both, you then have this discretion in terms of section 172(1)(b) of the Constitution, and then you can of course always say, well, pay back a portion of the one or pay all of it or set the two off against each other. But you have a wide discretion, and we thought just to point that out to you, the way that we see the case, perhaps that is a way to approach the practical effect of the decision made by the minister. May we then turn to our third point, because that took care of the first 2 points. Our third point, the attack on the constitutionality of the conduct of the minister as well as of section 8(9), we would like to say the following. First of all, and we're not going to repeat it, section 155 sub 7, read with section 229 2B of the Constitution, makes provision for the regulatory power of national government, i.e. the executive in this case. Now, in this case, the minister perhaps erred on the side of caution, in that the minister did not want to interfere with the surcharge that was levied on the domestic water, and she interpreted the provisions of Schedule 4B of the Constitution to say, I may not usurp myself that power. She was perhaps minded of the judgment in the case of Habitat. I don't know whether it was already given at that stage, but be that as it may, But we know that, therefore, from a constitutional point of view, we submit that a case can never be made out that the conduct of the minister was constitutionally not compliant. And it goes one step further, both in respect of the attack on her conduct and on the constitutionality of Section 8.9. It also goes, if one looks at the industrial water dispute. Now, what is important here is that one must go to Section 229 sub 2 of the Constitution and the power of the municipality to impose, and then we skip, surcharges on fees for services provided by or on behalf of the municipality. And then one must go to the Water Services Act, and then we say that you will give a consistent interpretation to the word services as it was used there. And if you look at in Section 1 of the Water Services Act, the definition of water services, it means the water supply services and sanitation services. And then if you go to the definition of water supply services, it says it means the abstraction and so forth and so forth. And then important, right at the end of it, it says, but not water for industrial use. So what you find is that in the Water Services Act, there is a clear distinction made with respect to industrial water. And industrial water is not seen as a service given by the municipality. In fact, if you look at it, the municipality, if they supply industrial water, they are merely seen as a provider of the water. And if you look at that same distinction, you will find in Section 21 sub 3 of the Water Services Act. That section deals with bylaws which every water services authority, i.e. the municipalities, can make. And then you will see in sub 1, it now deals with water services, i.e. water excluding industrial use. And then sub 3, 21 sub 3 says, a water services authority which provides water for industrial use, and then we skip to B, must make bylaws providing for at least, and then the 4 or 5 factors is taken into account. So the simple point we wish to make is the following. Industrial water, or the supply of industrial water, is first of all not a service, therefore not subject to Section 229 of the Constitution to take it outside of the ambit of the reach of the powers of the minister. And then may we just lastly make the point, and that is, it unfortunately assists Merafong not to say, well, I just give one quality water and that is potable water, and what the mine does with it. But if you go and look what the definition of industrial water is in Section 1 of the Water Services Act, it says it means the use of water for mining inter alia. So we just need to stop there. So it means the use of the water. So it's not the quality of the water that determines whether it's industrial water or not. It's the use to which it is put. We respectfully submit. So, and that we respectfully submit cuts across the attack against the conduct of the minister, as well as the constitutionality of Section 8.9. And may we just say one last point insofar as it may be relevant, and that is as to whether the court should entertain the constitutionality of Section 8.9. And of course, we take no view or support none of the parties here. But one of the considerations, of course, a court should always take into account is, of course, it's always desirable that one has the input of the courts below on that point. It's always of assistance. And Justice Tormay also made the very valid point. If you read the Water Services Act, there may be other provisions which actually ties in with Section 8 sub 9. And has there really been, have the parties really applied their mind? Because if you are going to attack Section 8.9, it may be that other provisions may then also be put in the same basket. Chief Justice and Justices, that's our 2 cents worth, and I'm glad that that my learned friend Mr. Mutepi is that his ancestors did not attack me as well during the argument. Thank you.
Thank you, Mr. Erasmus. Do you have questions for him, colleagues? No. All right. Let you off the hook. Anything in reply?
Chief Justice.
Oh, you want
very glad
you want questions?
No, it's so nice to be for government and not be on the receiving end for a change, Chief Justice. That's why I say that's very good. Thank you.
You're tempting us, Mr. Erasmus.
Yeah, tempting fate right there. And government does, find itself on the receiving end on occasion.
Thank you.
Mr. Graves, anything in reply?
Yes, thank you, Chief Justice. I just want to make sure. Yes, I see. Is the audio on and the video, Chief Justice?
Yes, perfectly.
Thank you. If I might respond briefly. From Merafong's, Mr. Mutepi's submissions, just to pick up on two primary ones. The first point is the submission was made that Anglo Gold takes the view that no surcharges can be imposed at any stage. That's simply wrong. We'd asked the court to turn up in the core bundle, CB10, which is the letter, this is the appeal of Anglo Gold, and to turn, first of all, to CB11. And what we find towards the foot of that page, just before the table, is the following. The tariffs announced by Merafong are considerably higher than that of Rand Water. It doesn't say that it can't be charged. We turn to the following page, which is CB12, and we find again in the middle of the page, the appeal is based on the fact that the tariff announced by Merafong is excessively higher than the equivalent Rand Water rate tariff while not adding any value. It says excessively higher. I don't know where our learned friend gets the point that we've strongly against, or that we've simply turned our faces against it. That's simply untrue. And it's not the case on the papers. Could I then refer to the point that was made with reference to the relief, the relief in the alternative notice of motion, which is sought. There's a passage in the replying affidavit of, sorry, I haven't, not, bear with me, sorry, Chief Justice, wrong one. It's volume 7. And if we look at page 732, sorry, it's not 7, it's must be 8. It's 8, sorry, it's 732. And this is where we deal with the amended notice of motion. And in fact, it starts on the previous page, 731, paragraph 66, the municipality's resolution, the tariff policy excerpts are next, on lawful and contrary to the Water Services Act. And then if you turn to the following pages, in paragraph 68, to the extent that the municipality may argue that the promulgation of increases and any subsequent promulgations confers legality on these increases, this is disputed. We can pause there. The relief which is sought by Anglo Gold, and that is in the amended notice of motion, which is RA1 in volume 4 at page 329. What is sought in that relief, although it's couched with reference to a review, it is in fact couched in the terminology of legality. Our enforcement, we seek an enforcement of the minister's decision based on the principle of legality. That we find it's part of alternatively the and or the principle of legality. But where it's come to, and the court may recall in this debate with our learned friend, what's come to now over a progression is that it's enforcement, and enforcement does not need to rely on either PAJA or any other provision. It relies on the principle of legality, which we've addressed, and which says that the three principles that we have cited with reference to Merafong number 1, that an organ of state is required to comply with those provisions. As was said in the Kurland decision, memorably in that decision, is that the state is not find the reference to that, if I may, a rather nice passage from the majority judgment. In paragraph 82, there's a higher duty on the state to respect the law, to fulfill procedural requirements, and to tread respectfully when dealing with rights. Government is not an indigent or bewildered litigant adrift on a sea of litigious uncertainty, to whom the courts must extend a procedure circumventing lifeline. It is the Constitution's primary agent. It must do right and must do it properly. That's what we seek, and that is the primary relief that is sought by Anglo Gold. So just bear with me. There was some debate about from our learned friend Mr. Botepi about the nature of the discretion. He referenced Trencon in that regard. As we read that, this is not an instance where it is what Justice Kapepi referred to as a true discretion, which I believe I regard as that is the narrow discretion. And in fact, we call into support the provisions or the provision in the judgment of the Supreme Court of Appeal when dealing with this. And if we might just bear with me. Yes, it's dealing with the paragraph under delay, and it's found on page 889, paragraph 26. And what the court said is that so too Merafong CC decided that the municipality was obliged to institute proceedings to review the minister's decision, whether under PAJA or by way of legality. And this is the important point. Whether that review is precluded by reason of the municipality's delay is also a threshold question for determination. And that, in our respectful submission, makes it entirely clear that, correctly so with respect, the Supreme Court of Appeal was looking at that question as what we would call the broad discretion, and in fact applied that broad discretion because it found that the judgment of the High Court of Justice Stratham did not properly apply it. It's a threshold. That's what Merafong was given the opportunity to refresh and to redo its challenge by way of a review. That is a discretion, and whether the discretion exercised with regard to delay, whether that was properly applied, is in the nature of a broad discretion. Sorry, Chief Justice. There've been a number of references to the minority judgment of Merafong number 1, and all we do is strictly refer the court to the judgment of this court in Turnbull Jackson versus Hibiscus Coast Municipality. That's 2014, volume 6. The South African Law Reports, page 592 at paragraphs 54 and 55. And the reference there, it refers to the doctrine of precedent. And the importance is that the majority judgment is what prevails. That is also the authority on the basis of the Supreme, what was the appellate division, and if I can just provide this, it's Fellner, or Fellner, F-E-L-L-N-E-R versus Minister of the Interior. That is sorry, bear with me. I seem to have lost the reference to that. I will locate that.
And you're down to 1.5 minutes.
Yes, thank you. It's a judgment that says that the majority decision is in fact what prevails. The reference, Justice Stradelman, was debated during when Justice Majid put questions. Is that although there have been matters raised relating to living out allowances and things, what was put to our learned friend was that there's nowhere expressly stated and with details as to what problems Merafong will have. We've assumed that there will be difficulties, but that's not something that can be generally stated. So in our respectful submission, that does not, it's not been properly raised, and the court will not pay much attention to that. Respectfully, the judgment in Tabutueo, which was debated between Justice Taron and our learned friend, Mr. Motepi, we respectfully submit that is the controlling applicable principle. Thank you, Chief Justice. Those are the brief. Oh, and our relief, we've already indicated that we seek, and we've given the reasons for that.
Thank you, Mr. Graves. Any questions, colleagues?
Can I just ask one question, please, Chief Justice? Mr. Graves, very briefly. Because when you say that this was a legality challenge, one inserted in paragraph 7 of the amended notice of motion, you mean then that questions of condonation and delay does not feature in terms of the 180-day rule in Paja and so on? Is that what your submission is?
With respect, yes, Justice Bridget. So we place it also in the context, it's enforcement. And we say the principle underpinning enforcement is legality. So it's in fact freed of those constraints.
Mr. Graves, thank you, Chief Justice.
Thank you, Justice Majid.
Anyone else, colleagues? No. All right. Thank you for your submissions, gentlemen. Judgment is reserved.
Thank you, Chief Justice.
Thank you, Chief Justice.
Today's proceedings have concluded. The host will now terminate the meeting.